There we go. All right, back to forms. I got two that are awfully similar, so we're going to spend more time talking about one, knowing that the other one, you know, is similar. So I got a buyer possession before closing and a seller possession after closing. In both situations, one party is acting as the landlord, the other party is acting as the tenant. Somebody owns the property, somebody else is living there. So buyer possession before closing, the buyer is taking possession of the property before closing, which means the seller's still the owner, but the parties have agreed to let the buyer move in early. Basically, we've agreed to let them take possession. So then the seller possession after closing means closing has happened. The buyer is now the owner, but they've agreed, they've allowed to let the seller remain for a period of time after settlement. To have everybody so far, one's the landlord, one's the tenant. It depends on who is the owner and who is the tenant. This form starts with a big red warning to buyers and sellers. This form may not be used for long-term occupancy, lease purchase, or lease option transactions. This form does not address important issues typically addressed in a residential lease, such as security deposit. Consideration should be given to using a residential rental contract or other residential lease. It also tells us the form number, form 410T. Buyer and seller are advised to confirm with an insurance professional the terms of the coverage under your property and casualty insurance policy before using this addendum. So property, seller, buyer. Terms of the possession, buyer can take possession on this property as of 8 a.m. on this date. This agreement shall terminate at the earlier of closing or the termination of the contract. So when we go to closing, the buyer's now the owner. They don't have to worry about possessing the property. If the contract's terminated, if it never makes it to closing, then that's also going to terminate the buyer possession before closing. I got more verbiage for that in just a second. This was just added, and I'm sure this was added for a reason. This was just added this past July, I should say. Seller should not access the property during the term without buyer's written permission, except in the case of an emergency. Seller shall be entitled to retain an entry key to the property, but shall deliver all other means of access to the property to the buyer on the commencement date. So again, a true tenant landlord situation, the landlord doesn't have the right to show up and enter the property without permission. And that applies to this buyer possession before and seller possession after also. By taking possession of the property, buyer waives any further due diligence rights. So if we're still in the due diligence period and the buyer takes possession, in effect, that's going to end due diligence early. Once they move in and take possession, that ends. Buyer waives the contingency under paragraph 11, and accepts the property as condition as of this commencement date. Buyer's waiver and acceptance is subject to any other agreements between the parties that are part of the contract, included but not limited to any agreements with respect to repairs or improvements of the property. Buyer's obligation to maintain, they shall not alter, modify, or damage or fail to maintain, make no changes, decorating or otherwise, without the written consent of the seller. The buyer needs to understand it's not your home yet. You can't go in there just yet and start doing a bunch of changes without the permission. In the event closing does not occur, buyer shall pay all costs necessary to correct alterations, modifications, or damage to the property to restore it in the condition it was. Because the buyer is renting, the seller has the right to collect rent. So we're going to address how much. We're going to start with a lump sum. Buyer shall pay seller a lump sum of X amount. If closing is delayed, buyer shall pay an additional rent in the sum of X amount per day. So we're going to start with a lump sum of the agreed upon time, but if closing gets delayed, how much per day does the seller expect to collect? If the contract is terminated, buyer shall immediately vacate the property and return all means of access to the seller. So if we find out we're not going to go to closing, when does the buyer have to move out? Is it next week? No, immediately vacate the property. If buyer does not immediately vacate, buyer shall continue to be bound by all the terms and conditions, and buyer shall pay seller a holdover fee of X amount per day for each day the buyer remains in possession until buyer vacates the property or is evicted. If I were the listing agent in this transaction, I would have a healthy holdover amount, very healthy holdover amount. If you're not going to go, you're going to give my guys lots and lots of money, because we got to try to get them out now, right? They're not going to get the property. We've said that closing isn't going to happen. Unfortunately, we'll see in just a second what the seller's remedy is to get this. Now they're a squatter at this point, to get this buyer out. We're going to address utilities. Buyer shall have all utilities registered in their name. Buyer's responsible for lawn maintenance and trash. Both parties have to have insurance, and it's of my opinion that making sure both parties have insurance is the most important part of this form. Whomever the homeowner is needs homeowner's insurance. Whomever the renter is needs renter's insurance. They need to cover their stuff. So in this case, again, we're looking at the buyer possession before closing. So the buyer's going to want to have renter's insurance. The homeowner is going to need to keep homeowner's insurance, make sure that the property is protected. We can't sublet or assign this agreement. The seller's still the owner, so they're on the hook for paying owners association dues. Whomever the homeowner is going to have the association dues. Can I include it in the rent to collect from the buyer? Well, of course I am. Anything is negotiable, right? So how much rent am I collecting and what does it cover? Pets are allowed or are not allowed. We have to agree to that. And then in the event of buyer's breach, buyer may be evicted from the property pursuant to a summary ejectment. So if we don't go to closing, if the buyer is a holdover or squatter and they're not going on their own, the seller's only legal remedy is a summary ejectment. Go in front of a magistrate and ask the judge to have them removed. They'll send the sheriff out there and start the process to get them removed. Cost of legal proceedings, the losing party in any legal proceeding against the other party for breach shall be liable for the costs and expenses of the other party. So again, if we have to go to court, whomever is the hurt party will probably have their legal fees paid for by the non-injured party. Let's see. Buyer signs on the left, seller signs on the right. And then we go through an awfully similar situation with seller possession after closing. Again, the difference is now we've been to closing and the seller is going to remain on the property. So we have to spell out the term. Seller shall remain for a period of so many days from closing. Buyer now has to agree not to access the property without written permission, even though it's their brand new home. The seller's still living there and they have the right to live there without interference. Seller acknowledges that all appliance systems and equipment are in good working order except for the following. So we're going to spell anything out here that doesn't work. Sellers living there, so they're responsible for maintenance and repairs of all appliances and systems. Buyers shall not be obligated to maintain property after closing while the seller remains in possession of the property. Seller needs to maintain the property in its same condition as closing. Again, now it's not there, so they can't make, once that deed changes hands, they can't make changes, alterations, etc. without the buyer, the new homeowner's permission. How much rent? Sellers have to vacate at the end of the term. If they don't vacate by the end of the term, they continue to be held by the terms. Seller shall is going to pay their holdover fee of X amount per day. Seller does utilities, trash, lawn maintenance. They're responsible. They're living there, so they're responsible. Seller's going to have to contact their insurance company and switch that to renter's insurance now. Buyer will have homeowner's insurance. Buyer's now the owner, so they're going to pay association dues. And then again, the eviction, if the seller won't leave, then the buyer's got to take them to summary ejectment and have a magistrate remove them. So again, pretty much the same thing. One party's acting as the buyer, one's or the landlord, the other's acting as the tenant. What do you guys think about these situations, these forms? Not forms so much, but the situation.
I'm not a fan. I've never been a fan of letting the buyer move in early. I just think it's a recipe for disaster, in my opinion.
I've heard lots of bad things.
Never advise my clients to do that. Never.
I've heard lots of, I would advise them to talk to your insurance company, talk to your attorney. When they looked at me and say, Julie, what should I do? I've heard a lot of these going south fast.
Oh, yes.
I will tell you guys, I've done one of each. I've done a buyer possession before and a seller possession after, and I really must be one of the lucky ones because I didn't have an incident with either one. Both of my people, both times, were great, but I'm thinking I'm one of the few just in talking to other agents out there. So I got lucky, it sounds like, and I absolutely recognize that. Yeah, Patricia, were you gonna say something?
Yeah, I was just gonna say, I try to get the sellers out as quick as possible. I don't let the buyers move in early. That's just like, the longer it lingers, the more anxious the other party gets.
Exactly.
What are they doing to my property now? It's like,
Exactly.
yeah,
Exactly.
so I just try to get them out and get them in. Just
get them in, get them out.
Get 'em in,
Change
get 'em
that,
out.
have that deed change hands, right?
get that deed change.
My seller possession after closing, I was representing the buyers, right? And they were moving up from Raleigh, and he had a job starting in like August. They found the one, and we were closing like the end of June. So they had a good 4 or 5 weeks before they actually had to be here. And they had planned on, the first couple weekends coming up and painting, cleaning, they were going to do the move-in gradual thing, right? And be here for a job. So the sellers were represented by another agent. And the listing agent called me and said that her sellers are building new construction and they faced a delay. It was like 4 or 5 day delay, which is so common in new construction. And they asked to do this because they had 3 children under the age of 5. And they said, if we only have to move these kids once, that would be better. Now I said, look, we understand if your guys don't like this. We just thought we'd ask, what does it hurt to ask? So my guys looked at me and they said, what are the risks? What do we do? So we had this conversation, went through the form and everything. But bottom line, they decided we weren't going to live here anyway. And if we can make some rent after buying a house, then, so it was like 4 or 5 days. My guys came up for closing and then they went back to Raleigh. No keys were changed hands, anything like that. We did get a copy just, for them as the owner to have. And then 4 or 5 days later, the listing agent called me and said, they're out. You want to meet up and get the key? And I said, yeah. And I went by the house to check on it. And y'all, those sellers left it. It was in immaculate condition. Everything was like spit shine from top to bottom. They left a thank you basket on the kitchen counter for letting them have those 5 days. I mean, it was a good situation. I also understand I'm one of the few. I'm one of the rare that and yeah, I understand how lucky we were, but the sellers were very appreciative that they didn't have to find somewhere else for those kids to live. And my guys were just thrilled that, you mean we're going to get paid rent on the day I buy my house? And I'm like, yeah, pretty much. We got a cashier's check coming for you, so I am aware of how lucky I've been with these. I'm very aware.
Yeah, with 3 kids under 5, that's what grandparents are for.
There you go. Patricia's sending them to grandma's house. There you go. Guys, bottom line, just make sure when this comes up, remember, I have to present all offers. So if my seller gets an offer to stay, or my seller gets an offer to let the buyer move in early, do I have to present that to them? Can I make? Absolutely. But I can still have the conversation, be aware, be cautious as we proceed if this is the route you want to go. If they have lots and lots and lots of questions, attorney, insurance agent, other people that can help get them the information they're looking for. Any other thoughts or comment? Buyer possession before or seller possession after? My buyer possession before started out for a week and it ended up turning into like 2 months. And after 2 months, that was no longer considered short term. So after about a week, we learned that closing was going to get delayed further. The sellers were in agreement to do what they needed to do for my buyers, which just blew my mind. They could have said, get out now and put my house back on the market so I can resell it. But they agreed to allow this to happen. And my buyers went to an attorney and had them draft up this 2-month lease, because this form, this short term, I don't know who defines that, but we all agreed that 2 months isn't short term. So yeah, they lived there for 2 months before closing on a different lease. Everybody understand that. We did not use this for the 2 months. We had something drafted up. But I went to the house right before closing. And again, it was immaculate condition. They hadn't even hung pictures on the wall yet. What had they done? They had them lined up on the wall. So they knew as soon as they closed where they were going to go. They had like this picture on the floor, this one. So they knew as soon as they closed where pictures were going to go. But as far as putting a nail in the wall, nah, they were waiting until it was theirs. So just make sure your people proceed with caution. And if they have questions, we're helping them get the answers. Another form we have. Owners Association Disclosure Addendum. This is a note, and this tells us we use this form when the RPOS is not required. So for example, if it's a new construction or if it's vacant lot and land, or by agreement of the parties. The residential property and owner association disclosure statement, that's the one where the seller says yes, no, and no representation about the conditions of the home. So if it's new construction, nobody's lived there, nobody can check a box about the conditions of the home unless they've lived there and experienced it themselves. So in new construction, the RPOS is exempt. It's not required. However, if the property is in an owner's association, the seller still needs to disclose to the buyer what that owner's association is and what it does. So the last page and a half of the RPOS is owner's association information. So in a sense, what we've done is taken that last page and a half, said, well, since y'all don't have to do the RPOS, we still want to make sure we get this information out. And that's what this form is for. Any representations made by the seller are true to the best of the seller's knowledge. Any copies are provided by the seller are true copies to the best of the seller's knowledge. So here's a place, again, identify the HOAs. Remember, we're not doing the RPOS. So we still want that information out there. What are the things that the owners association is responsible for? In other words, what do you get, what you pay for? And I like this a whole lot. It's pretty clear cut, right? You just go through and check boxes and say, these are the things that are covered by the HOA dues. As of this date, there are no other dues, fees, or special assessments except any identified below. As of this date, there are no unsatisfied judgments or pending lawsuits except those listed below. What are the fees? Move-in fees, transfer fees. We're going to identify those. And then here's that list of documents again that we see in the contract. We also see in the listing agreement. So if it's in an HOA, have our seller can help us get some of these required documents. Then of a conflict, this addendum will rule. Buyer signs on the left, seller signs on the right. Owners Association disclosure statement. And I got the lead-based paint. What's the magic year for the lead-based paint?
1978.
1978. You guys can see all your fingers going up in 78. Yeah. So lead-based paint or lead-based paint hazard addendum. This is kind of a dual form. It serves as a seller disclosure and it also serves as a buyer acknowledgement. So where we get this addendum, where this thing typically originates from, if the property was built prior to 1978, more often than not, this is going to be loaded in the MLS with the attachments along with the RPOs and the MOG that, you know, the other seller disclosures that we see before we ever go view the property. I think it's important that we understand this form does not say your house was built prior to 1978, it has lead in it. That's not what we're saying. What this form says is because your home was built prior to 1978, it may have lead in it. So during the due diligence period, buyers shall have the right to obtain a risk assessment or inspection of the property for the presence of the lead-based paint at the buyer's expense. Buyer may waive the right to obtain a risk or an inspection of the property at any time without cause. Intact lead-based paint that is good condition is not necessarily a hazard. We should all know and be familiar with and know how to access that EPA pamphlet, Protect Your Family from Lead in Your Home, for more information. You can go to EPA's website and order the pamphlet, the brochure. You can be frugal like me and get the free PDF download that you can send to your clients as well. But when we're working, we need to make sure we get a copy of that in our buyer's hands so they can help further educate themselves about the possible risks of lead in the home.
So it's not in Canopy under MLS?
It might be, I don't know, Canopy, but no, it's not an MLS. You might have it in like your dot loop or whatever. I'm not sure. But I know for sure, Patricia, we can get it from going to the EPA's website. Your firm may provide it, absolutely, but it wouldn't be an association thing.
Yeah, Texas is on our MLS.
Texas is what?
In Texas, it's on our zip forms. It's on our forms,
Okay, yep.
the PDF.
Disclosure of information on lead-based paint, lead warning statement. Every buyer of an interest in residential real property on which a residential dwelling was built prior to 1978 is notified that such property may present exposure to lead from lead-based paint that may place young children at risk at developing lead poisoning. Goes on to talk about the dangers, potential dangers of young children being exposed to lead in the home. Also mentioning risk to pregnant women. The seller of any interest is required to provide the buyer with information on lead-based paint hazard from risk assessments or inspections in the seller's possession and notify the buyer of any known lead-based paint hazard. A risk assessment or inspection for possible is recommended prior to purchase price. Did you guys hear what I just said? The seller of any interest is required to provide the buyer with any information they have, anything that's in the seller's possession, and notify the buyer of any known lead-based paint hazards. Let's go ahead and call this the exception to caveat emptor. The buyer doesn't have to disclose that, the seller doesn't have to disclose. They don't have to provide information per caveat emptor, with the exception of the lead-based paint. If the seller knows of any lead in the home, they've got to disclose that. If they have any reports from that lead, they've got to provide those reports. The only way a seller's going to know for sure and have reports is if the paint in their home was ever tested. If they're having contracted work done, that should be part of the contractor's job, is to send that out and have it tested. If they're do-it-yourselfers, they may or may not know that they can do that. You guys understand? So do-it-yourselfer might have it tested once they know. but contracted work should have it tested just as part of their job. And once the seller finds out, they're required to disclose. So the seller has some disclosures that they have to make.
Seller's disclosure.
Stop talking. Okay, I hit the, okay. So the seller disclosure, they have to disclose the presence of lead-based paint. Either they know of the lead-based paint or they have no knowledge. You guys know there is no representation here, is there? Either they know of lead-based paint or they have no knowledge. And then the second piece of their disclosure is the records and reports. The seller has provided the buyer with all available records and reports, or the seller has no reports to provide. So when you go see this property, when you first see this form as a buyer's agent, this piece of it should be filled out. Again, just like the RPOs and the MOG, we should be able to see that. Now that we're ready to present the offer, now the buyer has to acknowledge several things. They're going to acknowledge receipts of the seller statements set forth in the above. The buyer's going to acknowledge receipt of that EPA booklet. And then the buyer's got the option to check one. They either accept the opportunity to conduct a risk assessment or they waive the opportunity to conduct a risk assessment. Agent's got an initial. Agent has informed the seller of the seller's obligation under this USC and is aware of their responsibility to ensure compliance. So listing agents, we need to acknowledge that we've had this conversation with the seller, like, you know, if you know, you have to disclose. If you have reports, you have to provide those. And this is another form. Buyer signs on the left, seller signs on the right. But this is another form that you and I get to sign too. There's only two that you and I get to sign. And we're signing these, acknowledging, saying that we've had conversations with our sellers. We told the seller to disclose. We told the buyer their opportunity to do that risk assessment if they choose. I think it's worth noting there is a for rent version of this form. So if you're working with tenants that are looking at renting a home prior to 1978, we can help educate those tenants too. I don't think, and I may be wrong, one of you may correct me, I don't think unless the landlord grants permission, the tenant's not going to have the right to have it tested because it's not their home, right? So they can't run around doing all these tests and stuff. It's not their home. Now, can the landlord and tenant agree to do that? Of course they can. What we're saying is that if the landlord knows about lead, they've got to disclose that to the tenant. If the landlord has those reports, they have to disclose it to the tenant. But either way, we can still get this pamphlet to the tenant so they know about risk and dangers of lead. Comments on that?
Do, is there, okay, is there like a list of people that actually do these risk assessment tests that are local? Has anybody ever had one done?
I'm not sure about, I know like to do it, they got to chip off some of the paint. So they'll like go into the windowsill and chipping off some of the paint and sending it in to have it tested. I'm not exactly sure where sending it in. I'm not sure where that is located. Do you guys, any of you guys know that? I'm not sure. I know our home inspectors, a lot of cases can, you know, chip that off and send that in. So if your buyer wants that, most of the home inspectors, that can be accomplished through them. Listing agents, warn your sellers, the only way to test this is to chip off some of the paint, send it in. So don't let your, and I'm talking about paint usually around a door frame or a windowsill is typically where it's chipped off and sent in, but let your sellers know.
Yeah, in 30+ years, I've never had anybody really ask about it, but you know.
I personally never had anybody test for it. Yeah, me neither, Patricia. Other comments on that? Do I have any HGTV fans on this call? Do you guys watch HGTV? Sometimes a little bit. I can't stand that stuff. I guess I do it all day, so I want to watch it, and it drives me nuts because that stuff's not real, like not even a little bit. But I swear that's why I have a lot of people sign up for pre-licensing, because they watch this stuff and they think that's it. You got to show 3 houses and they pick one and everybody's happy. Okay. I do know this, and I don't, but Chip and Joanna, they're like house flippers. You guys hear about this? A couple years ago, they got themselves in trouble. Why? They mishandled some lead-based paint stuff. I think they bought a home and flipped it, and I don't know if they knew or they didn't have the test or they didn't have reports. I don't know the full story. But that's, to me, was the moment that HGTV got real, because that was a very real scenario, mishandling various things such as how you disclose the various reports. So I certainly don't celebrate anybody getting caught or in trouble, of course, but it just goes to show is that this is a real thing if it was even happening on HGTV. Now they probably paid a fee and did what they had to do, and they're back up and running a business now. You know, so they didn't skip a beat, but to the right flipper, that could have been game breaking, you know, game changing.
Gotta pay attention to details.
You got to pay attention to those details, and you got to follow the rules.
Lives
It's
of
just as
family
simple
are
as
at
that.
stake, you know,
Do what?
I said people's livelihood is at stake.
Exactly. Exactly. Absolutely.
Not to mention your referrals.
Yeah, future business. Absolutely. That's a good point. Vacation rental addendum. We're not going to spend a lot of time on this. Lindsay, if you ever decide to do residential, because of where you're located, you know, down closer to the coast. I know you said you're close to the beach. Patricia, where are you? Remind me again where you are. You in Charlotte somewhere?
I'm in Statesville, your
You're in
hometown.
Statesville. I knew that. Yeah. So Statesville's a little different market. Vivian and Jory and I are here in the Triad. Triad in Statesville, don't get me wrong, are wonderful places. People aren't vacationing here though. They may come here to visit family. They may come here for work, you know, the High Point Furniture Market or something, but they're not coming here to vacation. So I say all that to say we probably don't deal much with vacation rentals in our neck of the woods. Like I said, Lindsay, if she ever gets into residential, may encounter it, but I think I know where we use this form most is going to be down at the coast or up in the mountains. So if you ever move either direction and get closer to water or mountain, then know that you may get to deal with this form a lot more. If the property being sold is currently used as a vacation property, a vacation rental property, then this tells us the property is subject to the vacation rental agreement as defined by, in North Carolina, we have a Vacation Rental Act. So that's one good place to start to learn more about vacation properties is the Vacation Rental Act. Seller, so the couple big things about the Vacation Rental Act, the buyer buys honoring existing vacation leases for the first 180 days after they purchase. So any vacation rentals that are on the books, when the buyer buys, they have to honor the first 6 months, the first 180 days. If they're going to buy it as a vacation home, they may choose to keep everything on the books, right? But if they're buying it for personal residence, they need to know that they can't do anything with it for the first 6 months. They can cancel reservations after that. Similar to a landlord-tenant situation, the seller has to provide the buyer with copies of those rental agreements, copies of the lease agreements. If there were any deposits put down, that money has to change hands. You know, that piece of it seems to be very similar if the buyer's buying a home with an existing lease in it. I'll let you guys look this over when you're there, when you're ready to do this. But I think that's the big things. Here's our 180 days. Seller has to provide buyers with copies of all those things, which again is the same thing as any landlord tenant situation. You know, if we're going to buy by honoring existing leases and tenants, then I deserve to have all that information. Questions on that? We'll come back to that one in just a second. Here's another form. You may have remembered when we looked at our offer to purchase and contract, I only had a place for 2 buyers to sign. I only had a place for 2 sellers to sign. So the question comes up, what if I have more than 2 buyers or sellers? Well, now we have an additional signatures addendum. So this goes on. I got 1, 2, 3, 4, 5, 6, 7, a place where it looks like 7 more buyers and sellers to sign. So now I have 2 on the contract. I have 7 here. So now I'm up to 9. What if you need more than 9 people sign? You do another additional signatures addendum. You do as many of these things as you need. Every single person that has to sign that deed to convey needs to sign, and their spouses. Every single person that's going to purchase, and the lender may require spouses. So all those signatures that we need, we got a form to get everybody signing, saying that they are on board. If it's an entity, you might be multiple entities joining together. So I only got a place for 1 on the contract. So if you have more than 1, we can use that additional signatures addendum. This page is still, this is just still 1 page. I wonder how much longer they're going to be before they think of something else to add, make it longer. But this is one of the few 1-page forms we still have. Additional signatures addendum. If we're getting up to, you know, using this form, I tend to think of more like an estate situation, maybe heirs and their spouses, for example. I remember one time I was going after for sale by owner. I didn't get it, but I was going after it. And it was an estate. Grandma left the property to the 4 grandkids, and all 4 grandkids were married. So now we got to have 8 people signing everything. Another form. Let's talk about our backup contract addendum. This is a form we're probably seeing more in this market than what we have. This is one of these forms that have always been around, but now in this crazy market, we're starting to see it more and more. As this market dwindles down, we might start seeing it less and less. So this is a form. We're going to be reminded in just a bit. I have a duty to present all offers to my sellers, all of them, even if I'm already under contract. Even if I've already contracted, another offer comes in, I've got to present that offer to my sellers. And if that other offer comes in while we're under contract, it should come in with a backup contract addendum. So the big picture in this, we're under contract. Another buyer is hoping to get their offer accepted and the hopes of being in a backup position. That's all that we're trying to do here, is create a backup position for the second buyer. And if you think about it, it's really kind of funny. They're off to the sidelines, fingers crossed, hoping and praying that the primary buyer terminates. Because if the primary buyer terminates for any reason, our backup is in. They're hoping it falls apart so they can get in and get under contract.
Are there any buyers, are buyers agents allowed to present to the sellers themselves here?
Absolutely. Absolutely.
Listing
Agents
agents are on board with that?
Some do and some don't, but there are cases. I work with a lady, she absolutely presents her buyer's offer. And if she can't get straight to the seller, which she tries to, of course, the listing agent should be there when buyer's agent's talking to the sellers, of course. But absolutely, when we talk about presenting an offer, it's not just emailing it, is it? It is actually presenting, it is actually explaining, going over the details. So can they present directly to the seller? Sure. Buyer and seller acknowledge that seller has previously entered into an offer to purchase and contract with this person's name. This person is referred to as the primary buyer under the primary contract. They acknowledge that they're currently pending and that this is a backup contract is accepted in a secondary or backup position under the following terms and conditions. So again, let's back up and practice what we're talking about here. We're under contract. Another offer is presented and now it has this backup contract addendum. This is attached to and made part of the offer to purchase and contract. So when you're presenting this backup contract addendum, you're presenting your buyer's offer with it. It's an addendum that attaches to it. Buyer and seller go through and negotiate the terms of the contract like they always do. We're going to negotiate the purchase price, due diligence, earnest money. I'll talk about dates in just a second. Upon acceptance of the offer, what this form does is put that buyer in a backup position. Okay, so we've already agreed to the terms, termination of the primary contract shall be evidenced by, so we'll see in just a second that the seller has to provide a written release, written notice of termination from one party, from the seller, from the buyer. Notice we can't just say it's terminated. We need to have some kind of evidence. We need to have some kind of backup. Buyer's not going to do anything until and if their backup becomes a primary. So they don't owe due diligence until they become the primary. They can put earnest money in escrow account to show their good faith, but if they never become the primary, they're going to get that earnest money back. So they can still show their good faith. They can still put it in. If the primary closes, the backup shall become null and void. Here it is. The earnest money deposit shall be refunded to the buyer. So again, they're still putting up earnest money, but it's just sitting in escrow as good faith money. Here's our dates. And this is where dates get a little interesting with the backup. The backup buyer doesn't know if and when the primary is going to terminate. Thus, we don't know dates yet, specific dates. So what this part of the form allows us to do, instead of putting a date in due diligence, we're going to put a period of days that's effective upon receiving notice of being put in the primary status. So once that backup buyer is notified that the primary contract is terminated, now the backup buyer becomes the primary and they have however many days for due diligence, or however many we agree to, however many days that is. And same thing with the settlement. Does that make sense? I can't put a date in here, but we can put is a number of days that starts upon being notified that you are the primary. There's a note here that tells us instead of inserting dates, we're just told to say, see attached backup contract addenda. So the contract itself will direct us to this portion of it right here. Again, earnest money is going to go on in the escrow account. Due diligence is not due and payable to the seller until they've been given that notice of primary status. The buyer doesn't owe any money as the backup. Does that make sense? They only owe money as the primary if they've been given that notice. Buyer's right to terminate this backup without liability by giving written notice of termination at any time prior to receipt that they are the primary, and the earnest money deposit shall be refunded to the buyer. So even though they're a backup buyer, they're still not locked in. They're just positioning themselves. As a backup buyer, we could go out and keep looking at property, couldn't we? And when they find the next best thing, we just terminate this and get their earnest money back, but it gives them a place in line. You can only have one backup buyer at a time. So it's not like we can't have these things succeeded out, right? One backup buyer at a time. That's all this form allows for. You don't have a backup to the backup or a backup to the backup to the backup. That came up a lot in this market. You get 40 some offers, only one of them get accepted. How many backups can we have? If your buyer wants to be a backup to the backup, now we need to get an attorney to draft us up a form because I don't have verbiage for that covered here.
And Julie, the due diligence would work the same as with just one buyer.
Exactly. Nobody owes that due diligence until you become the primary.
Okay.
So the backup doesn't owe the due diligence until they're notified. That's right. We could do an automatic termination. Buyer must receive notice of the primary from seller no later than 5 p.m. on this date. So maybe now we're getting closer to the primaries closing. For example, at some point we got to concede that the primary is going to close, right? So we could put a date in here. Everybody good with that? Buyer's not losing any money as the backup. They don't do anything. They're not going to start inspections. They're not going to do anything, appraisal, nothing until if they're notified that they're in as the primary. Buyer signs on the left, seller signs on the right. The rule does require that sellers provide written notice that the primary is terminated. So that's what this last page does. Notice to buyer that backup contract is now in effect. This is where the seller can give them written notice. The backup has now become the primary, evidenced by the attached document that shows that the primary was terminated. Seller sign saying the backup contract is now in effect. Have you guys ever done one of these? Those of you that are practicing, have you done one of these? Jory's done one of these. Were you the listing agent or the buyer's agent?
Buyers.
So your buyers got in as a backup?
Nope.
Oh, they didn't accept it. You know, pluses and minuses, right? Some sellers are very overwhelmed in this market. Go ahead.
Well, I have yet to close a deal with a buyer.
Okay, you will though. You will. Some sellers are very overwhelmed in this market. Y'all, I told you, one of my teammates had a house on the market a couple months ago now, 8 weeks ago, something like that. We were on the market for like 3 days and they got like 45 offers. 45 offers. Those sellers were overwhelmed, right? Wouldn't you be? So sellers are very overwhelmed, and some sellers may see this backup contract as a, look, you're telling me if we terminate, I don't have to go through that showing circus again. I don't have to open my home to everybody coming through. I don't have to look at 45 offers again. Some sellers see this as a good thing. Other sellers are going to say, no, I don't want to back up, because if the primary falls through, I want to pit everybody against each other again. Maybe I can get more money. You know, so every seller thinks of it a little bit differently. When we have a backup contract presented to us or offered to us, we do have to present it to our sellers, because we have to present all offers to our sellers. So when your seller looks at you and says, which one should I do? Which should I do? We just need to help them weigh their options out. If this buyer walks away right now, are you willing to go through all those showings again and receive all those contracts? If that's something you want to do, maybe we can get you more money. I don't know. It's a risk, isn't it? Unlike Jory, I was the listing agent. It was early in the multiple offer world that we're living in. I'm going to say this was a listing back in 2016, 2017. And we were just starting to learn about multiple offers. It was like my first one and I was kind of blown away by it, you know. But I had 6 offers come in. Of course, we can only accept one. So 5 of them got rejected. And one of the 5 that rejected came back later with a backup contract. But here's the weird thing about it. Maybe you guys can help us understand. The terms they offered in the backup were less than their original offer. And when my guys countered, they countered back with the terms that they originally offered to the T. We actually went to the first offer and said, well, the first time you offered us this, this, and this, and that's what we countered with. and they said, no, thank you, we're gonna walk away. So I'm not sure if they were upset that we didn't pick them. I mean, we countered with their original offer. Does that make sense? And they still said, no. All right, we tried. So that's the closest I ever got to a backup contract, again, as the listing agent. As it turns out, that primary buyer closed and this wouldn't have happened anyway. But I found it really interesting that they came back with lesser terms than what we knew for a fact they were willing to offer. So I'm not quite sure what kind of game we were playing there, but it didn't last long. I know that. Comments on the backup? The last one we're going to look at right now, I got one more to look at later, but we're going to talk about it when we get to it in the that portion. You guys there? I just lagged a little bit. Okay. Short sale addendum. I like this form for many reasons. First off, this form starts, we're going to define a short sale in just a second, so it helps us out with that. First off, I got a blue note telling us the backup contract addendum should not be used in conjunction with this form. We'll talk about why in just a second. This form manages multiple contracts when necessary. That does not say offers, does it? This says that this form manages multiple contracts. So that's why we can't use the backup contract addendum. Again, we'll explain that in just a second. Property seller buyer, and as I mentioned, the first thing I like a whole lot about this form is it tells everybody what the heck a short sale is. And a short sale is consistent of three pieces. The purchase price is not sufficient for the seller to pay off their debts, their liens. They're underwater. They owe more than the property is worth. Okay, we probably have multiple mortgages, maybe a judgment, personal liens, right? We got several different liens on the property and they can't sell the home to pay off all that debt. The second piece of that is, and the seller does not have sufficient liquid assets to pay the costs. So what we're saying is the seller can't sell the house and drain their savings account and pay off all their debt. So there's two pieces. And then the third piece is the lien holder has to agree to release their liens at an amount less than what they're owed. So lien holders, all of the lien holders have to agree to do this. Every single one of them. They all have to agree to receive less than what they're owed. If I can't get the lien holders on board, they don't clear those liens. If they don't clear those liens, the seller can't convey clear marketable title. So there's a short sale defined. We'll talk about the process in just a second. Short sale approval risks. Buyer and seller understand and agree that no lien holder is required or obligated to approve a short sale. Again, we'll talk about the process in a second. Lien holders may require some terms of the contract to be amended, including acceleration of the due diligence period and settlement date, but buyer and seller are not obligated to agree to any of the lien holders' proposed terms. So let's back up just for 1 second. If a property is advertised in MLS or outside of MLS as a short sale potential, we have to disclose that it's a short sale potential. I can't call it a short sale just yet, though. It's not a short sale until the lien holders get involved. So you see a property that's advertised as a short sale potential. Buyer submits an offer. Seller and buyer negotiate the terms of the offer like they always would. That piece of it doesn't change. This is an addendum, which means it's attached. Upon acceptance of this contract, now the process for the lien holders to approve begins. The lien holders aren't going to start their thing until we have a bona fide contract in our hand, until we have a buyer and a contract. So the lien holders haven't done anything yet. We've just gone under contract. Now we send this contract to all the lien holders to get their approval to clear the lien for less than what it's worth. What this is saying is they're not obligated to approve a short sale. Just because it's a proposed short sale doesn't mean that the lien holders are going to agree to do this. They may require some terms of the contract to be changed. The lien holders may say, we want a shorter due diligence or a shorter closing date, but the buyer and seller are not obligated to any of those lien holders' terms. So the buyer and seller are the ones creating the contract and setting the terms, but the lien holders are the one that have to final approve that. What I'm telling you guys is this short sale addendum creates a contingency. There's a contingency on the seller that says, I can't sell you my house if I don't first get all of the lien holders' approval. There's no guarantee with this thing. We got to get everybody on board. Everybody's understanding that seller may not be financially able to make repairs, even if the buyer asks and the seller's willing to help them out. The lien holders may say, oh, no, no, no. You owe me money. I'm not going to let you put $10,000 down on a new roof or $5,000 down on electrical. If you got an extra $5,000 laying around, you're going to give it to me. So it's not that the seller doesn't want to make repairs in this case. They may not be allowed to. They may be very strict on that. The cost of the due diligence and the due diligence fee are not refundable to the buyer in the event the short sale is not approved. So buyer's agents, if your buyer's going after a short sale, I suggest going in heavy on earnest money because I can still protect that. But they need to be aware that they may not get their due diligence or their due diligence costs back. Lien holders may take several weeks. That's not accurate, or more likely months to obtain. And neither the seller nor any real estate agent representing the seller or buyer can guarantee the timeliness of the approval, rejection, and nobody, buyer, seller, closing attorney, nor the brokers have any control over lien holders' approval or any act, omission, or decision by the lien holders in the short sale process. The name of the game in a short sale is to be patient. I've done 2 of these now as buyer's agents. I was a buyer's agent both times. They say, whoever they are, they say on average, you need to allow 6 months for these things from contract to close, 6 months. One of my short sales was 4 months. The other one of mine was 11 and a half. There's nothing you can do. My buyers are like, can't you call the lien holder? What do you think I am? I call the lien holders. Have you guys had a chance to review this file yet? It doesn't work that way, you guys. We got to be patient. We got to let them do their things. They got to crunch their numbers to make sure that they're okay with losing money. And if we don't get approval, then this contract is killed. That's what we're doing with creating the contingency. Sellers of acceptance of the lien holder's approval upon obtaining written short sale approval from all necessary lien holders. Seller agrees to promptly provide buyer with written notice of seller's acceptance. Until notice of approval, either party may terminate by written notice, and the earnest money deposit shall be refunded to the buyer. Again, the buyer may have to put down some due diligence, but they're going to get their earnest money back unless they terminate after due diligence. Does that make sense? So that's why I say go heavy with earnest money. Try not to help them lose as much more due diligence than what they have to. Both of my short sales, you want to know what the due diligence amount was? We went all in on earnest money. We went all in. Oh, we just lost Jory. So, you know, it's all negotiable, right? And in this market, it might be different. Both my short sales went down before sellers were in the driver's seat. So it might be different, but I fear coming out of this market, we might see more foreclosures and short sales in our future. So we're going to have more and more to deal with these. Same thing with the dates that we saw. I don't have a date I can put in here because I don't know how long until we get that approval. So the best we can do The short sale addendum tells us 15 days for due diligence and I think 30. Yeah, 30 for settlement, but we have the option of putting in another number of day here. So if you want more than 15 and 30, you do. Again, it's all negotiable. The parties have got to agree to this. Other offers and additional contracts. Rules of the North Carolina Real Estate Commission require offers from other buyers received by the seller's agent to present it to the seller. The Real Estate Commission also requires the seller's agent to inform lien holders of all offers and contracts to sell the property received after request for short sale has been submitted. So first thing we have here is commission rule reminding us, if I'm under or if I get an offer for a short sale, do I have to present it to my seller? Yeah. And if I get another offer while we're already under contract, do I have to present that to the seller? Yes, the rules require me to present all offers. Seller hereby represents to buyer that there is or is not an existing contract of the sale of the property. What I'm telling you guys is you can have multiple contracts with a short sale. There is no backup. There are multiple contracts. And you know which one the lien holders are going to choose? The one that gets them the most money, the one that helps them to lose the least. Does that make sense? And in order, what we're saying here is in order for the lien holders to take everything in consideration, if another offer comes in, gets accepted, becomes a contract, it's all a contingency. Remember, this whole form says, I can't sell you my house if I don't first get approval from the lien holders. So if the lien holders doesn't give approval on the first one, then hopefully maybe the second, the third. You guys with me? Multiple contracts. Does that just go against everything we thought we knew about contract law and everything we thought? This is what makes short sales so much fun. They go against everything we thought that we knew. I just told you 11 and a half months that we were under contract. You don't do that outside of a short sale. Welcome back. We missed you. Offers from other buyers may be accepted by the seller and become a sales contract. These are known as additional sales contracts. Seller or lien holders may, prior to the notice of approval, elect to substitute any existing or additional sales contracts for approval by lien holders and withdraw this contract from consideration. Unless the contract has been terminated, seller shall promptly notify buyer in writing of the occurrence of any of the following events: seller's acceptance of any additional sales contract. So if we're under contract and another one comes in, the seller still needs to notify, hey, there's another contract on this home. Short sale approval or seller's closing on any existing or additional sales contracts. If not sooner terminated, this contract shall become null and void upon the completion of closing. I got verbiage here. What happens if the seller goes into or has the seller represent that they're in foreclosure? Are they in bankruptcy? You know, it's important that the buyer knows there could be other financial issues going on here besides the short sale. It might be that if the short sale doesn't work out, the seller has to go through foreclosure. The short sale might be like the last ditch effort to try to save them a little bit. And the last piece I think is important, especially if this is something that's coming back. Listing agents, we need to know how to handle these. Sellers advised to talk to everybody, aren't they? Seller needs to talk to their attorney. They need to talk to an accountant. They need to talk to me and you. Anybody that can properly advise them on this transaction. I'll share with you guys the 11 and a half month one that I did. The listing agent, her email signature boasted her as a foreclosure and short sale specialist. And my first thought was, golly, that's a heck of a way to make a living. Patricia, is that you? My hat's off to you. That's a heck of a way to make a living. But you know what? She had her niche. She had her uniqueness that the rest of us are like, God, I don't want to touch that. You know, and you got a couple agents. And I tell you, that listing agent was on point. She knew her stuff. And even though it was 11 and a half month transaction, she made it as smooth. She was communicative. I mean, she was amazing, understanding there was only so much that was in her control. The rest of it was sitting on the desk of a lien holder somewhere, waiting on that approval. That 11.5 month one, by the way, not to scare y'all, I think what made that one so long, there was an outstanding lien to the IRS. And I don't know if you guys, what we know about the IRS, but rapid response isn't one thing that they're known for. So that's what we spent a long time waiting on, was the IRS. Buyer signs on the left, seller signs on the right. And then the last page is the seller's opportunity to tell the buyer, your short sale's been approved. The lien holders have been approved. Now that we have this notice of approval, now the buyer can start their thing. I didn't have my buyers do a home inspection until we got this. I didn't have my buyers start the loan process. Don't spend any more money until we get this letter right here saying that you've been approved, and we can now move forward. And we move forward like we always do. We have X amount of time in due diligence, terminate for any reason or no reason. If you terminate after, you lose the earnest money, yakety yak. Patience. The name of the game with these things is patience. Questions or comments on this one? Trisha, you do these?
Yes, ma'am.
Listing agent?
Yes, I had listing agent and I also was a buyer's agent. But you know, the thing about it, when the prices go up, just like we've had a market where the prices have been truly inflated, when those tax appraisals start coming back and people realize how much they overpaid for these properties, it's a psychological state of mind.
Yep.
That they are not paying for what they bought, and the short sales start happening. And the cool, not so cool, but in some banks, they change the person, your contact person, the executive person you're working with, they'll change them every 90 days. And then they have 2 weeks to get caught up on the file. So when it goes 6-9 months, it's like you done changed people 3 or 4 times.
This is why I did not
And
know
that's
that.
why.
Thank you for sharing that, because you basically move from one desk to the
To
next.
the next,
And every time you change desks, you got to give me, you said 2 weeks?
they get 2 weeks to catch up.
2 weeks to pick it up and look at it. Oh my gosh,
Yes.
that's new information. Thank
And Bank
you.
America was horrible. Just absolutely.
Yeah, I've heard that.
Yeah.
I don't keep anything on my desk for 2 weeks. That doesn't seem fair. Do what I
Well,
need
knowing
to
that they may have had 100 different short sales. too.
Yeah, it's not the only one, and I get that. And let's face it, the bank's not happy about losing money. I mean, so they're not like, but while this is going on, they're probably not getting much money. They're not getting a mortgage payment. Whether or not the bank allows you to do a short sale or requires foreclosure, bottom line to the bank is going to come down to which one's going to cost me less, which one is going to cost me the less amount of time. So whether or not you do a short sale comes from permission from your bank, approval from your bank. If they say it's a foreclosure, then this isn't an option.
And they do have to submit their financials to the bank to
Yeah.
show what their
Oh
position
yeah.
is.
They got to show that they don't have, like I said, these liquid assets. They
Yeah.
got to show. I mean, I'm sure there's not many stones unturned.
Not at all.
The other thing I will say on behalf of the seller, foreclosure is going to stay on your financial history, your credit history for like 7 years. A short sale will only stay with you for 3. So as the seller, if you can get this, if you can make this happen, then it's not going to stay with you as long. But again, it's entirely up to the lien holders, and that's multiple, y'all. That's plural, because there is usually more than one.
And you could be taxed for the difference.
And you could be taxed for the difference. And after settlement, they could file a deficiency judgment,
Bam.
which would put a flag on you personally. Anytime you go apply for a loan for anything, home loan, car loan, home improvement loan, whatever, that's going to show up. So talk about kicking you while you're down, right? But if they
Yeah.
put that deficiency judgment on you, you're going to have to make up the difference.
They will send you a statement for the shortfall. And if they take a debit, then it's got to be credited to somebody. even
That's
though it's
exactly right.
dollars.
That's
No,
exactly
but it
right.
does give the seller potential time to save money. If it takes, I've kept people in a house up to a year. you know,
And
and if
let them,
they're
because they gotta
smart,
find somewhere else
they
to
gotta
live,
go,
save some
you know,
money. That's right.
save your
That's
money,
right.
prepare, for this transition. And
That's right.
smart ones have done it. The crazy ones end up go live with their parents somewhere.
Oof. No fun. Other questions or comments on the short side? Jory, have you done one of these yet? Oh, you just wait. Oh, you just wait. You gotta have some patience.
I
That's
don't
what I
think
keep
the money's
saying over and
worth
over.
that
Do
one.
what?
I don't think the money's worth it for that one.
I don't know. Price, because with both of mine, I still got full commission. Now, sometimes agents may not, right? That the seller may not be labeled, but both of mine, I got full commission. So the 11.5 month one, I got every single penny. I should have. I waited long enough. All my years in sales, that was like the only closing that I couldn't attend. I was out of town this week. I didn't know that 11.5 months ago when we went into contract that we were going to close this week, So while they were at home closing, and I sent a teammate to closing, it's not like I just sent them on their own, good luck. I did send somebody, but of all the closings that I could never personally attend, it was my 11.5 month short sale, but that's all right. I was hanging out in New Orleans, doing my thing while they were home up here buying a house. So it was a win-win and everybody worked, everybody. I celebrated in my own way. Some buyers got nothing but the audacity. That's true. That's all they got. All right, let's take a break. It is it's 2:51. So let's come back at 3:02. 10 minutes, please. And then I think we're done with forms for now, just for now. So 3:02.
You look pretty lonely being there by yourself.
I feel lonely. I don't know. Everybody just, Lindsay just dropped off. Joy just dropped off. I'm not sure what happens to everybody's. But we just lost some. So hopefully they'll come back in just a second.
While we're waiting, Vivian, tell us about your restaurant.
Um, it's, my partner's the chef. And it is Southern inspired. It's full service. BC, before COVID, we were 6 days a week. We did lunch and dinner and Sunday brunch. Right now, we simply do dinner service. But we have I think a pretty good wine list. And in January, we'll celebrate 20 years in service.
Oh,
That's
My
awesome.
partner was nominated in this last round. She was a James Beard nominated semifinalist for Best Chef of the Southeast. We've been written up in any number of periodicals throughout the country. We've been on Turner South Network and a couple other things, Food Network. So.
we have a celebrity in our midst.
We
Mm.
do. We do.
No, we just got somebody like you, Patricia, and the rest of you that just go to work every day and try and make it happen.
But it's always good. It's always good to be recognized for your efforts sometimes.
Yeah.
Definitely. Definitely. Vivian, you can probably say more to this than I can, but prior to the pandemic, BC is what, pre-COVID, before COVID, businesses in downtown Winston were also suffering because they had to close business 40
Mhm.
for what were they, 9 months, 10 months, something like that.
So it was actually 18 months.
Oh gosh, where was I? Okay, so 18. So there was all this period that they were actually directing people away from downtown because of the closure. And it ended up being a lot longer, I think, than what so I know that a lot of businesses suffer from that. And then about the time that they opened 40 and everybody's trying to recover,
Mhm.
then COVID hit. So downtown Winston's had hit a couple good hard times.
So we've been hit quite a bit between really between 2017 and now. When at the height of it, it really knocked out quite a few restaurants and not even just restaurants, any
All
kind of small
businesses.
business.
Mhm.
It's really an art-based kind of city. And so there's lots of artists, sculptors, painters, what have you. And they've had a rough time of it. So, but
Well,
we're
congratulations to
coming
you
back
guys
out of
for
it. And people are coming back to the city. We get a lot of tourism from our convention center. A lot of conventions are here. And so hopefully in the next year or so, things will continue to get us back on an even keel.
get back to normal, whatever that is, right? So definitely glad you guys pulled through. And you weathered those storms and others. So like you said, the restaurant business, you've been at it for 20 years. I don't have to tell you this. You're going to have another storm, kind of like real estate. There's highs and lows, there's good and bad. So the trick is, can you weather it? Can you get through it and look forward to the next market? So
you got to be able to pay your bill, but the rest of it, the bulk of it is having the right state of mind.
that's it.
It's good or bad, nothing lasts forever.
That's exactly right. That's exactly right. So thank you for sharing. Let's see. I got one more form to talk about. We'll talk about that in just a minute. Just any questions in general on these forms? Like I said, you guys, you're gonna have a situation. I don't need you guys to study the forms word for word, but just have a basic understanding of what each form does. So if you have a situation and the test question and it asks which form should you use, then you'll be able to just have that basic understanding. So we'll quickly review a couple of them tomorrow or Wednesday when we do our our review. By the way, to avoid confusion, I know I keep saying tomorrow. So if I say tomorrow again, we all know that that means Wednesday, right? Y'all don't try to come on the call tomorrow. That's our tomorrow, I guess, is why I keep saying that. So, but what I mean is Wednesday. All right. So we're going to get back into our PowerPoint, back into Unit 11. And, just a reminder, you got these pages in your book that talk about the various provisions of the 2T of the offer to purchase and contract. What I like even better is the guidelines to complete. So for those of you just getting started here in North Carolina, I think the guidelines to complete answers a lot of your questions. It's knowing where to start. So I think that's a big piece of what post licensing does, is help you guys get these answers so you can use them in your career. So you have the guidelines for completing, you have your real estate manual, you have the Real Estate Commission's website. And I think I mentioned this the other day, but when you become a member of your local board of association of realtors, and then that gets you into the North Carolina Association and the national level, right? The 3 different tiers of the levels of the associations. We have a legal hotline at the North Carolina Association of Realtors, which means we have access to legal help. You can call or send an email. I'm more of an email kind of gal myself. I've emailed them before and I've gotten a response from an attorney that day. So the hotline and the emails available through NCAR. I know a lot of agents sometimes complain about membership dues. That's just money going out the window. What do I get? What is a perk that we get? I get access to an attorney. What would it cost me that email if I didn't have that access? You guys with me? So utilize the resources and the tools that we have available to us. Okay, so what we need to do now, of these pages, starting on 335, we're going to go back just a little bit. And we've talked some about the earnest money when we were looking at the contract, but we need to go back and have a little further discussion about the earnest money, make sure that we've discussed everything that we need to know about the earnest money. So we're going to go back. Remember, you got my page numbers down here at the bottom. So the earnest money is negotiable. The earnest money is negotiable. The whole point of the earnest money deposit is to show the buyer's good faith. The seller wants to know that this buyer is serious about buying their house. They don't want buyers that are out there just kicking tires and are going to terminate, tomorrow or the day before settlement. Now, I understand we don't have a crystal ball and there's no guarantees, but the seller wants to know coming into it that the buyer is serious. Earnest money is not required for contract formation. Remember, the amount is completely negotiable. As a matter of fact, the Real Estate Commission says the earnest money deposit, the amount, whatever the buyer is willing to offer and the seller is willing to accept. So if the buyer offers 0 and the seller accepts 0, we have created a legally binding contract with 0 earnest money. It's completely negotiable. It's whatever the parties. I don't have a formula. I can't say, well, if the purchase price is X amount, then it's a percentage of that. Da, da, da. No, it's whatever the buyer's willing to offer and the seller's willing to accept. And like we've been talking about in this market, the biggest earnest money due diligence combo I've heard, it was like a $450,000 home. There was like $175,000 put down between earnest money and due diligence. And my one and only thought was, where the heck are these people getting this kind of money? Why don't I have $175,000 laying around? But I don't, so I guess I don't have to worry about it. But somehow they had cash stuffed in their mattress or something. I don't know. But somehow they came up with it. And we're going to start seeing these amounts come down. Remember, our contract tells us that the earnest money, along with the due diligence fee, that's what that DDF, due diligence fee is the seller's sole and exclusive remedy. Now, the only reason that the seller could potentially sue the buyer, the only reason is if the buyer's home inspector damages the property and the buyer terminates and said, I'm not going to fix it. If there's damage to the property caused by the buyer, the seller may choose to go after them in court. Have them call their attorney if they think that's what they want to do. Earnest money deposit. Our contract tells us that the earnest money is due within 5 days of the effective date. And we're going to revisit that effective date in just a bit. Make sure we're good with that, when that is. Commission rule requires the earnest money be deposited within 3 banking days of receipt or contract formation, whichever one happens first. Whichever one of these happens first, start your 3-day banking day deposit. Let's say, for example, we went through this scenario last week. You're in the throes of negotiations and your buyer says, here's my earnest money check. Hang on to this for me while we're negotiating the contract. Guys, I'm not under contract yet. We're still in the throes of negotiations. The buyer doesn't owe any money until a contract is formed. Everybody with me? The buyer doesn't owe any money until a contract is formed. So if they say, here's my check, hang on to this for me, do not take it to the bank. We need to safeguard it until a contract, and if a contract is formed, in which case we now have 3 banking days from contract formation. Does that make sense? Even though we received it, we're not going to deposit it until 3 days from the contract is formed. I think typically the way that it works, the way we actually see it played out in practice, we go under contract and then we get the checks from our buyer. So we're under contract and then we're looking at 3 days from receipt. Full brokers can hold on to earnest money deposits during negotiations. Guess what? As provisional brokers, you guys cannot. As a provisional broker, if you guys are handed an earnest money check by your buyer and you're told to hang on to this while we negotiate, you've got to immediately get that earnest money deposit to your BIC. Provisional brokers cannot walk around with somebody else's money. Full brokers should not, because bottom line, when you have somebody else's money in your hand, it's your responsibility. So my suggestion to you is always get it to where it needs to go. Let your BIC be responsible for it. But specifically, commission rule says provisional brokers cannot walk around with somebody else's money. If they hand you that check and say, I know we just started the contract negotiations, the offer negotiations, but I want you to hang on to this for me, you guys need to run, not walk, to your broker in charge and hand that to everybody. Good with that? If a contract's never formed, then we're going to get that money back to the buyer. Either void the check, shred the check, destroy with it, mail it back to them, destroy with it according to their wishes. Again, if an offer never becomes a contract, then a buyer doesn't owe anything. They don't have to pay anything. I had a buyer once, perfect example. He lived in Florida. He was moving his family up from Florida, a relocation from work. So he took a week off work. They flew up from Florida. We looked at property Monday, Tuesday, Wednesday, Thursday. Friday, we finalized second showings and finalized. He handed me 2 checks. Bless you. He handed me 2 checks, one for the earnest money, one for the due diligence, and then he got on a plane and he went back to Florida. But he wanted those checks in my possession because he knew as soon as he landed in Florida, check your inbox, you're going to have a contract there for me to sign, right? And then probably by the time he got home, I was presenting his offer. So he knew how quickly this was going to happen. I appreciate savvy buyers. But then again, that's why they have us. He relocated a lot. So he moved a lot. So he had this process down. Not all buyers do. So if a contract's not formed, and I asked him, I said, what if they don't accept these amounts? What if we never go under contract? You want me to void it? You want me to shred it? You want me to mail it back? And he said, void and shred would work. So I was prepared to take a picture of a voided check and then to take a picture of that thing being shredded so I could show it being destroyed. I was prepared to document that I had destroyed, and according to his, we went under contract though, and it all worked out, so it wasn't an issue. Yes, ma'am. Oh, I thought Patricia had a, no, you good?
Oh, no, I didn't know. How do you, oh, okay, you know that anyway. I've been given just signed checks and they get on the plane.
Yeah, I
know.
wouldn't like that. I don't like
Yeah.
that.
Yeah,
Ooh, the
no,
liability of
it
that.
was, well, on one side, it's a blessing that they trust you enough for that.
Yeah, but I
Because
guess they've
you
already made
truly
it
hold
out to
that.
the agent, right? I mean, or the escrow
What if they don't
agent.
get that one?
But what if they don't get that one? So they haven't even made it out to anybody.
I
Yeah.
check with a signature on it, girl.
Anybody's heartbeat just go up a little bit? My anxiety level. You talk about being responsible for something.
Absolutely.
Woo. Yeah, definitely want to safeguard that. You may want to get with your BICs about, and firm's policy on that. Today we have the benefit of overnighting. We go into contract today, I can get a due diligence check from you tomorrow, no matter where you are. We also today might be able to do wire means. Maybe we can do wire transfer or Cash App, Venmo, something like that. Remember what we said last week, you guys, just make sure you get the lender's approval before you start doing these electronic means. Because if the lender doesn't approve it, then they're not going to get those amounts credited back to them at closing. So before you tell everybody it's okay to Cash App, you may just want to pick up the phone and call the lender and make sure they are okay with that. I'd rather be safe than sorry. We talked about the various things that happens to the earnest money deposit. In the event of the seller breach, the buyer will get their earnest money back. If the seller breaches within due diligence or without due diligence, doesn't matter. The due diligence period is not for the seller. So if they terminate the day we go under contract, if they terminate the day of closing, if the seller's in breach, the buyer should get that money back along with their due diligence. If the buyer terminates within their due diligence period, the seller keeps the due diligence fee and the buyer gets the earnest money back. If the buyer terminates after due diligence, now the seller gets both. And our contract tells us that is the seller's sole and exclusive remedy. That's their money damages or their liquidated damages, due diligence and earnest money deposit. Enough of this doom and gloom. What if this thing actually makes it to closing? The earnest money will be credited back to the buyer. So if we actually make it to closing.
Not both, just the earnest money?
And the due diligence, yep, both.
Oh.
Yep, but we're just talking specifically, about the earnest money, right, thank you. So yes, if we make it to closing, both earnest money and due diligence will be credited back to the buyer. They've already paid that money once. So now that we've made it to closing, they shouldn't have to pay it again. As we said, provisional brokers can't walk around with somebody else's money. So if you're handed an earnest money deposit, you must, as a provisional broker, deliver it immediately to your broker in charge. As a full broker, you should. Yeah, that's why they get paid the big bucks. Let them deal with that. Again, you guys, whenever you have somebody else's money in your hands, you're responsible for it. So just make sure you're aware of taking on that responsibility.
So agents can take cash here?
If the firm policy allows. It's not ideal, but if the firm policy allows. So if you are handed cash, regardless if we're in the throes of negotiations or not, go ahead and deposit that money. We don't have to wait for cash to clear the bank, right? Like we do a personal check. So if we're in the throes of negotiations and your buyer hands you $30,000 in cash, get it in the bank, safeguard it. And if that contract's never formed, or have your BIC get it in the escrow account, not your bank, but have the BIC get it in the escrow account. And if that contract's never formed, we just cut them a check for that amount. We're not going to keep cash in the office. There's a commission rule that addresses handling of any monies. You don't need to know the rule number, just know there's a commission rule about it. We can also accept money. We are allowed to accept money for the purposes of delivering. So it's not uncommon, for example, for us to have, like we said earlier, buyer's agents. You go under contract, yay. You're going to meet your buyer somewhere and get the earnest money deposit and the due diligence fee. The reason you have those money in your hands, you're acting like courier, aren't you? You're acting like delivery guy. So we are allowed to do that. We are allowed to help in delivery, getting it from point A to point B. What we need to understand is when I have that money in my possession, I'm going to follow the directions of my buyer. It's their money. I'm just helping them deliver it. So you go under contract, yay. Send the contract to your lender and closing attorney. You meet your buyer in a parking lot somewhere this afternoon, and they give you 2 checks, one for earnest money, one for due diligence. Everybody with me so far? Those checks are now in your possession, and you are en route to deliver them. You're en route to deliver them to the escrow agent and the listing agent. And you're still in your hand, you're en route, and your buyer calls you and says, do not deliver those checks. Bring those checks back to me. Commission rule says it's their money. I follow their instructions. If they say, do not deliver that money, I say, are you sure? There could be legal, there could be termination, there could be all this other stuff. The buyer says, I don't care, don't deliver it. We've got to follow their instructions. It is their money after all. Another good reason why I say, when it's in your hand, get it to where it needs to go. Because once you've delivered it, it's no longer in your hand. So what do they have to do now? I don't know. I guess they got to call the escrow agent or the seller to try to get it back. Commission Rule A.0116 also addresses disputed earnest money. So if buyer or seller terminate, the earnest money is not automatically released. Remember, the escrow agent, the escrow account is just a unbiased, very neutral holding ground. It's somewhere where we can all put the money and know that, I mean, you're not going to put it in the seller's trust or the seller's account, right? So we have this neutral holding ground. And now the contract's terminated, and one party is not signing to release the earnest money. My guess is going to be the party that's not supposed to get it. So if we're in due diligence and the buyer terminates, the seller may drag their heels about releasing it. If it's after due diligence and the buyer terminates, the buyer may drag their heels about releasing it, right? That means the money's in dispute. The escrow agent can't release the earnest money deposit until the parties are in agreement. Even though they have a copy of the contract in their hand, even the closing attorney, if they were an escrow agent, they can't say, well, the contract says right here what's supposed to happen to that earnest money, so I'm going to do it anyway. The parties have to agree to release it. And if they don't agree after X amount of time, and I don't remember what that X amount of time is, not important, but after X amount of time, the escrow agent can turn the money over to the clerk of courts and let the two go downtown and hash it out. They have to send like a certified letter to the last known address of both parties, right? Like they got to make a couple attempts to get them to release it. But if they follow the rules, the general statute there, if neither party releases it, then we just turn it over and let them go downtown and hash it out. We don't need to get involved in that. Questions or comments on earnest money? If we look, I thought I had it. just to point out, the Real Estate Commission's website, ncrec.gov, we've found some pretty fun things in this here. And again, if we click on publications and publications, we're taken back to where we probably spent the most time in this class looking at various things. And let's go one more time into Q&A brochures. I got a Q&A. Here's a due diligence for residential buyers, and here's an earnest money deposit. So when you're explaining earnest money, when you're explaining due diligence to your buyers and sellers, we got the forms here. We got the Q&As to help. So we have these tools at our disposal. And I'll let you guys look those over. I just like to let you know that they're there. I mean, there's fair housing, home inspections. We might have looked at that one. Just some good stuff in here to help us better communicate with our buyers and sellers. This was the most recent one that they created. Why test your well water? I also want to, I'm going to stop sharing just for 1 second. Bear with me. I'll throw this in Learn Test Pass if you guys want. This is a really good article that the commission put out. Just this past February, that's addressing the high amounts of due diligence fees that we're seeing in this market. And what I like about this article is it tells us is that the due diligence fee has always been for the buyer's right to terminate. If they're wanting to put down $50,000, it's not my job to tell them not to. My job is to explain the risk. My job is to make sure that my buyer understands if you put down $50,000 in due diligence and you choose to terminate, you're not going to get that $50,000 back. Everybody has a different risk tolerance. Yes, some of us are more apt to go out and buy a lotto ticket than others. Everybody has a different risk tolerance. And part of what we can do as buyer's agents is help our buyer identify that risk and know what they're willing to lose. Obviously, we want it to close, but in the event that it doesn't, this is what you're risking. So this article, and guys, that's on us. If buyers don't understand they're not getting their due diligence back, that's our fault, because that means we're not explaining it to them. We're not having this conversation. The rights of a buyer during the due diligence are the same, whether they have paid 0, 100, or 100,000 in due diligence fees. It doesn't change. The amount of due diligence doesn't change. What's happening in this crazy market is buyers were terminating because they found electrical and thinking they were going to get their due diligence fees back, and find out that they weren't, but they wanted to put down $50,000 to be competitive. And again, I say all this to say, this comes back on us. This is totally on us. If we're not explaining what this is about, then we need to do a better job. So I'll throw this in Learn Test Pass for you guys, but I think this is very relevant, very in today's market. Even though we're coming out of our crazy sellers market, we're still dealing a lot with some of these high fees. No matter how rapid or swift the market is, that doesn't negate our responsibility for explaining the terms of the contract to our buyers and sellers. That's our job. All right. Continuing on in chapter 11, the last little piece of chapter 11. We'll get through most of this today, if not all of it. Tomorrow I'll have a little bit more to wrap up, but not a lot, just a few more things to say. We'll do our closing disclosure, number 4, homework recommendation, and then start getting ready for tests. So we're just clipping right along. So this last little piece in chapter 3 is our sales contract procedures. And in chapter 11, we're going to talk about submitting offers to our sellers. We're going to talk more about multiple offers. And then we got some other modifications, excuse me, just kind of review our modifications and counter offers. So kind of a nice refresher from last week. In order to create a valid real estate contract, first off, an offer has to be made. An offer has to be considered. Eventually, to form a contract, that offer has to be accepted, and we've got to have communication of acceptance. We have to have both of these pieces to go from being an offer to a contract. So let's go back and draw a little picture again. Again, I think this is a nice refresher from last week to help us get ready for this week. So you have the buyer on one side of the wall, the seller on the other side of the wall. The offeror is the person making the offer. Maybe it's the buyer, maybe it's not. More often than not, the buyer's making the offer to the seller. Yes? But I need you guys to understand the seller could make an offer to the buyer. The seller could make an offer to sell. So when you see offeror, I would rather you guys think the person making the offer than think the buyer. I think that'll help you get through your test. So the buyer makes an offer to the seller. The buyer's the offeror. The seller's the offeree or the receivee. The sellers receive the offer and they have three choices now, don't they? They can accept it, reject it, or counter it. If they counter it, it's a rejection. A counter offer is a rejection. If they counter it, the roles reverse. The offeror becomes the offeree becomes the offeror. If they reject it, this offer's dead on the table. It's done. There's no reviving an offer once it's been rejected. We can't go back. But let's just say they accept it. The buyer makes the offer. The seller looks at it and they say, yep, that looks good. I'm going to accept it. We need to verify that it's been signed, because if you got verbal acceptance, you got absolutely nothing, right? So we need to make sure that it's been signed. And once it's been accepted, the second step says communication of acceptance has to cross the line. The person making the offer has got to be notified that their offer has been accepted. I need both of these pieces in order to form a contract. Now, I told you guys last week, you're going to have a test question. It's going to be like this long, and you're going to have an offer made, and it's going to be countered, and da-da-da-da-da. And in the end, you need to know, when did this become a contract? So you're going to want to draw it out, and you're going to want to see when the last offeree signs it, and you're going to see when that communication crosses the line. You also want to make sure you're looking for methods of communication. If I leave you a voicemail and then I follow it up with a text message, which is the one that put us under contract? It's the voicemail.
Voicemail.
Yep. I only need communication of acceptance to cross the line once. Everything else is me. Hey, Lindsay, did you get my voicemail? Hey, Lindsay, did you get? Everything else is me verifying that you received that one form of communication. So as I mentioned, I will let you guys have scratch paper because you got math. So I'll let you have scratch paper. We'll talk about that tomorrow. But when you see this test question, I do suggest that you draw it out so you can see who is the last offeree that has to accept and who is the last offeror that has to get communication of acceptance. So back to our little scenario over here. Let's say in the event of a counter offer, if you're drawing it out, it's going to look like this, right? Buyer makes an offer to the seller. Seller has three choices: accept it, reject it, or counter it. In this case, they've countered it. So now that means the roles have reversed. Now the seller is the offeror making an offer to the buyer. What are the buyer's three choices? They can accept it, reject it, or counter it. If they accept it, we have acceptance. And then in order to form a contract, the buyer has got to notify the seller that their offer's been accepted. What questions do I have on this?
So the communication of acceptance is going to be the actual signing or what I call the execution of the contract?
Communication of acceptance is me saying, hey, Tricia, my guys have signed. I've communicated to you that my guys have accepted. So to your point, if we bring agents into the mix,
So signing is not part of the acceptance.
signing is acceptance. Now that it's been signed, we got to communicate said signature. We got to communicate that it's been accepted.
Okay, so acceptance, signing is first.
That's right. That's right.
Okay.
I sign it, but it does you no good if you don't know I signed it, right?
Okay.
So I sign it and then I got to communicate with you that it's been signed. That's what I need, both pieces. Just because you sign it, if I'm none the wiser. So I need to know, I need to be communicated with that you've signed. Yep.
Okay,
And
so
remember
then-
when, go ahead.
okay, so in that acceptance of communication, if they've signed it, so it means both parties signed it. So if I'm sending it to you in email as an executed contract, that's, so is my voicemail the communication of acceptance, or you receiving it in email as a fully executed contract?
Which one came first? Did you call me or did you email me?
I called you.
Bam, that's what put us under contract.
There you go. Okay.
Okay. The
Okay.
email is just you following up, right? It's the first time you tell me, whatever method you use to tell me, it's the first time you say, Julie, my guys have signed this. We have accepted. And like we said, once you put agents in the mix, remember you guys, when it comes to contract formation, communicating with the agent is the same as communicating with your client, right? So let's say that Patricia is the buyer's agent and I'm the listing agent. Okay, so we're working with buyers and sellers respectfully. Buyer makes an offer, seller counters, buyer accepts. Buyer has signed the counter offer. They call their agent, Patricia, and say, we have signed. Are we under contract when they call Patricia? Are we under contract when they call Patricia? I'd like to see all of you move your head one way or another. Are we under contract when they call Patricia? No. Why not?
Because there's no communication to the other side. to
You didn't communicate to the other side. So is it a step for the buyer to tell their agent, I've signed, I've accepted? Is that one of the steps? Yes, but it's not a contract formation step, right? They've signed, they're told their agent. Now Patricia is going to call me or email me or text me or whatever and say, my guys have signed. Boom, we're under contract. As the listing agent, obviously the next thing I want to do is call my sellers and tell them the good news. And when I call my sellers, I'm not saying, are y'all sure? I'm calling my sellers and saying, congratulations, we are under contract.
Okay, Julie, so I need to put a wrinkle in this.
Oh, good.
We haven't talked about it, but it exists. I'm the dual agent.
Ah,
So do I need to pass that from buyer back to seller? Or do I just accept it and keep moving?
we just got to accept it and keep moving because, and I started saying, but let's just say Vivian is the dual agent, which means Vivian is representing the buyer and the seller, right? Vivian is representing both. Vivian is the line. So when the seller calls Vivian and says, I've accepted, has communication crossed the line? Because communicating to the agent is the same as communicating to the principal. And in the case of Vivian saying where you got one agent or one firm acting as a dual agent, now that line kind of looks a little bit different, doesn't it? So Vivian, to your point, all these previous examples and what you're going to see on your test, This is a co-broker transaction. This is Patricia working for one firm and Julie working for a different firm. That line gets a little bit different when dual agency brings in, isn't it? Thank you for the wrinkle. Because that brings up a whole different. Now, Vivian, let's pretend for a second. If this is what dual agency, now let's pretend that we got designated. And now we got Vivian with one firm representing the buyer, and we got Jory with another firm representing the seller. Once you're designated, you pretty much stand on both sides. You stand on your respective side. You exclusively represent your buyer or seller. So now we got to have communication crossing the line again. So see how different forms of agency. And if you haven't taken 301 yet, my out-of-state people, bear with us. You'll get all about agency and how in North Carolina we do dual and designated and all that in 301. So just kind of bear with me for now. Like I said, for your test, it's going to be a situation of a co-broker transaction. Each agents are with different firms. But things absolutely shake up just a bit when we start getting into dual and designated. Lindsay and Patricia, have you guys taken 301 yet? Patricia has, both of you have? Okay, good. Not that I was trying to avoid dual agency and designated dual agency, but I don't have time to cover it if y'all want to get through this. That's a whole different conversation for a whole different day. Good, I'm glad you guys did 301. Okay, everybody good on this? I highly recommend you guys draw this out on Wednesday. You got to see who the last offeree is. We have to know the last person to sign, the last person to accept, and then we got to make sure that that communication crosses the line to the other side. You got to be notified that your offer has been accepted. And guys, remember, in the real world, when the other agent calls you and says, my guys have accepted, your knee-jerk reaction, you shouldn't even think about it. The very next thing that should fall out of your mouth should be, have they signed it? Because we need to know that we have verbal acceptance or if we have written acceptance. Because if you got verbal, we have absolutely nothing. So when that other agent calls you and says, my guys have accepted, but has it been signed? Because that's all that matters. Other questions? I did an open house a couple years ago, again, before this crazy multiple offer world that we're living in now. And this couple came in, and at the end I said, oh, do you guys have any questions? And they said, yeah, we're feeling a little defeated. They said, we're working with an agent and we were under contract to buy a house, but the seller backed out. I said, oh, I'm sorry to hear that. And they said, well, they said they were going to accept our offer, but they never signed it. And they said, we're sorry, but we don't play that game. And I thought to myself, sir, this isn't a game. This is contract law. This is how these things are formed. Clearly what happened, I'm guessing, and I didn't get, because they're not my clients and I didn't want to get too involved, but my guess is that they were told they were going to accept. And before the seller signed, it sounds to me like a better offer came swooping in. And the seller signed that better offer. And I hate it for those guys. I do. But it's just another reminder that if you got verbal, you got nothing. You have absolutely squat until you got it in writing. So we need to verify. We need to make sure. As we've been saying, the offeror is the person making the offer. The offeree is the person receiving. I really want you guys to get it out of your head that the buyer is the offeror and the seller is the offeree. Please stop. The offeror is the person making the offer. The offeree is the person receiving the offer. More often than not, it starts with the buyer making an offer to a seller. But remember what we said in a counteroffer, those roles reverse. So just by saying the offeror is the buyer, what if you're in a counteroffer? Or like I said earlier, the seller can make an offer to sell. They don't have to wait for the buyer to make an offer to buy. the seller can make an offer to sell.
Can
The
you give
offer
me a,
or
can you give a quick example of that?
seller making an offer to sell.
Yes.
So I had sellers a couple years ago, real life example. I have this for you. And we got an offer in and it wasn't great. Like my sellers were up here and the buyers were down here. And we negotiated all day. I mean, it was back and forth all day long. We finally got to like here, right? We weren't even close. It was kind of a wasted day, but we got to like this point. And my seller said, you know what? We're not getting anywhere fast. We're tired. We don't want to do this anymore. Just reject it. I said, you sure? Once it's rejected, it's dead on the table. And they said, yeah. We'll find other buyers. We're fine. We're tired of playing these games. I said, okay. So I called the agent, followed up with an email or text, and I said, thank you guys, but we're rejecting it. Best of luck to your buyers, blah, blah, blah. You want to know the phone call I got about 7:30 the next morning? It was from my seller saying, we slept on it. We want to accept that offer, that last offer. Can we go back and accept that offer? Could we have gone back? No, because we rejected it. It was dead. So at this point, what's our other option? The sellers, I prepared a brand new offer on behalf of my sellers and submitted that to the buyers. We made an offer to sell, but and it was based on the last terms that we had done. But we went back and I mean, there is no going back. So in that case, we couldn't go back and, void the rejection. It was already out there. The universe had already seen the rejection. So our only other option at that point, Vivian, was basically start over. We presented an offer. The buyer has three choices. They can accept it, reject it, or counter it. They did accept it and we went under contract. There may be cases if a buyer is, another example of a buyer's kind of interested and maybe something happened to the seller's sense of urgency. Maybe today their need to sell is greater than it was yesterday. So they may make an offer to a buyer, maybe not of asking price, but trying to get something in there to entice the buyer. We use the same form. We can still use 2T, but instead of the buyer's agent completing it on behalf of the buyer, now we're looking at this at the listing agent completing it on behalf of their seller and making that offer. Offers are revocable, which means the offer or the giver of the offer can revoke their offer at any time prior to acceptance, even if they put an expiration date on it and we're still in that designated time frame. If I make an offer right now on behalf of my buyer and I say this offer is good till 5 p.m. on Wednesday, my buyer calls me tomorrow and says, we want to revoke, can we? Yes. The offer or is free to revoke their offer at any time prior to acceptance. The offer or is free to revoke their offer at any time prior to acceptance.
So if the seller verbally accepts the offer and says, I'll sign it in the morning, and the buyer in the morning calls and says, forget it, and it has not been signed yet, or even signed but hasn't come back over the other side, it's a done deal, right?
Yeah.
It's dead.
Yep.
Okay.
Yep. You got to have two pieces, acceptance and communication of acceptance. And if we don't, remember, if you got verbal, you got nothing. So if the seller says, yeah, I'm good, I'll sign in the morning. Guys, we as agents need to say, wow, tomorrow morning's great. You know what's even better? Right now, or after dinner, or, try to get them. And again, hopefully we're having these conversations up front, especially in the different markets. If you're going on a listing appointment today and you're not talking to the sellers about how many showings they're going to have on day one, if you're not talking to sellers about how many offers they're going to, you know what I'm saying? We got to prepare them for these things. You're getting ready to be blown away with showing requests. You're getting ready to have a lot of showings. We're getting ready to have multiple offers. Are we going to have 2 or are we going to have 42? I don't know, but we're preparing the sellers for this. And that might also be a conversation of, things move rapidly. We got to stay, especially when it comes to communication. So offers are revocable. The acceptance, an offer must be accepted and acceptance must be communicated. So I got to have both of these pieces. And remember, when we looked at our contract, the effective date says the last date that everybody signed and when communication has been told to the other side or something like that. It's contract law. But I say when the last offeree accepts and that communication of acceptance crosses the line.
So that prior slide said offers are revocable. I'm
That's
sorry.
right.
Thank you. I wrote irrevocable.
Oh, no. They are, meaning the offeror can revoke their offer at any time after acceptance. After a response or acceptance, now that's irrevocable, right? But what we need to understand is the offeror is free to revoke their offer at any time prior to acceptance. Yep. So I hope what we're getting for all this is that agents, we need to communicate promptly. We need to be in touch. Guys, I don't know about y'all, but I would have a hard time putting my head down tonight and going to sleep knowing that my buyer didn't get their dream house because I was slow on my communication, because I didn't get that communication across the line. In the meantime, another offer came swooping in. I'd have a really hard time looking myself in the mirror if I knew I was the reason why. And this happens a lot too. Patricia calls me, or my client calls me and says, we've accepted. Maybe we'll do it that way. My client calls me and says, we've accepted. And I say, great, I'll wait and tell the other agent, I got to run some errands and do this and swing by the grocery store. So I'll do that tonight when I get home. Do you know how much can happen when I'm out running errands and swinging by the grocery store? Now that other offer swoops in, I never felt like making the phone call because it was too much of a hassle for me to deal with. And now they're under another contract with another property. So let's face it, these things are tethered to us anyway, right? For those of you just getting into real estate, like your phone, because this goes where we go. And I can't tell you how many random parking lots I pulled over in the years. Be safe. Safety's always first. But how many times I've hung out in a Sheetz parking lot or McDonald's parking lot trying to communicate acceptance or finalize some deal because I don't want to wait until I get home for fear of my lack in communication ruins this deal for somebody else. So and honestly, this is one of the hardest pieces of me for being a real estate agent, because sometimes, especially when we're in the throes of negotiations, we're on 24/7, aren't we? Do you think the buyer and seller are going to take a break while you go to the beach this weekend? We are on all the time. There's an old saying in this industry that says, if you want to sell a house, just go on vacation. Because I promise you, about the time you're pulling your suitcase out of the closet, this thing's going to be ringing up. All your listings are going to sell. All your buyers want to make offers. I promise you, that's Murphy's Law. That's how it works. So have a buddy, have a friend in the office that can help you. You scratch my back, I'll scratch yours. Make sure if you're not going to be available for a period of time that you have somebody to cover, because the show has to go on. And I fear a lot of my peers, a lot of us agents out there are afraid to take a vacation because we might miss something or we might miss out on something. And I think that's a mistake too. If the president of the United States of America can take a vacation, then so can the real estate agent. Dang it. We all deserve that time. We all deserve a vacation, but you got to make sure you're covered while you're gone. You got to make sure you're covered. You don't want things falling through the cracks. And you better take your laptop to the beach with you anyway, because at some point you're going to need to check in. I remember 3 or 4 years ago, I was still kind of in sales. I was working on getting out of it. And my husband and I did a cruise. We'd never been on a cruise before, so this is our first time cruising. And my husband said, all right, we got a choice. We were looking at our expenses. He said, we got a choice. We can either get the drink package or the Wi-Fi package. You know which package I went with? Hint, it wasn't the Wi-Fi package. So I knew I was going to be 5 days disconnected. I had to make sure my stuff was covered while I was gone. You know what? It was a good 5 days. You need to disconnect every once in a while. Well, I had the drink package to help forget about my lack of Wi-Fi, so that was. But you got to make those decisions sometimes. You guys, we got to take a break. Come on. Speaking of break, let's take a break. Let's see, what do we got? 3:58. So let's come back at 4:09 and we will wrap up for the day. welcome back. So finish up this last, 49 minutes or so. Like I said, we'll finish everything Wednesday morning. We don't have much more to talk about. Anytime you guys take a class with the Real Estate Commission, post licensing or CE, you got to talk about a current license, an expired license, how do you keep it active, that kind of thing. So we'll go through that. Don't forget on Wednesday, we're going to do our homework recommendation, which is that closing disclosure problem number 4. I'm guessing you guys have been in Learn Test Pass. I'm guessing you guys have accessed that. Remember, you need a blank closing disclosure for your test on Wednesday. So you may want to today or tomorrow or even Wednesday morning. But by the time we get together for Wednesday afternoon, you guys need a blank closing disclosure. We'll talk more about that because I need to verify that it's blank. So we'll talk a little bit more about that on Wednesday as well. Any questions about what Wednesday looks like? We'll probably do what we need to do, wrap up, do our closing disclosure, do a review, go through my exam expectations. That should give us time to still take a lunch. We don't have to take a full lunch if you guys don't want to, but we do need to take some kind of lunch. We need to give you guys just a minute and rest your brains so we can even take a vote, 30 minutes, an hour. It doesn't matter to me. I want to do what's best for you guys, 50 minutes, whatever. And then you get 3 hours for your test. So as long as we get started by 2, you guys will have your full time for your test. I think we'll get started a little bit before then. But that's just kind of what Wednesday looks like. So, questions about that, what Wednesday is going to look like, what our goal is, plan is?
How many total questions are there, Judy?
There's 40. Excuse me, I was drinking water at that exact moment. There's 40 and you can miss 10. Okay. So
And
let's-
best way to
yes.
reach you on, say, Tuesday, will that be by email?
Email or text if you have any questions. Yep. I teach tomorrow 9 to 1 pre-licensing, so I won't get back to you tomorrow afternoon, but just let me know if you have questions. Absolutely. I mean, I get 10-minute breaks in pre-licensing too, but just now my 10-minute break was spent unloading my dishwasher and so I get busy. I'm like, oh no, what time is it? And I'm just trying to keep up with the wonder that is the kitchen. It amazes me. I don't understand. We don't even eat at home at night and it's still like the kitchen needs tended to. I don't get it, but that's what it is. All right, so let's switch gears just a little bit, not too much, but let's talk about submitting offers to a seller. Now we have different schools of thought here. And we're going to see that both schools of thought that we're going to talk about is pretty closely related. So that's the good news. We don't have conflicting information. When we talk about submitting an offer to a seller, I'm talking about 2 groups of people. I need to make sure we're clear here. If you're the listing agent, a seller has hired you. So if you're a listing agent, you are working directly with the seller. Once you are in possession of an offer, you have a duty to deliver that offer to your seller. What if you're a buyer's agent and the buyer is interested in a for sale by owner? Aren't you, as the buyer's agent, communicating directly with the seller? You're not their agent, you're not representing them, but aren't you the one communicating directly with the seller? So if your buyer wants to present an offer to a FSBO, submitting offers to a seller is going to apply to that as well. You're submitting it on behalf of your buyer. Everybody with me? So any seller we're talking about, represented or unrepresented, no matter what role we have, listing agent or buyer's agent working with a FSBO, we have a duty to submit that. So again, I got 2 schools of thought, and we're going to see that they're very closely related. The law of agency is where our rules of agency all started. This is how it was formed. This takes us back to the days of England. I guess this is timely, isn't it? When we had a king, this is before we had the queen for the last, bless her heart, for the last, however long she was with us, a long time, but way, 60 years, 70 years. Wow. Way even before her reign, way, think like medieval Renaissance day. The law of agency was formed because that's how the people treated their king. They treated their king as the master. They put him up on a podium, a throne, for goodness sakes, you know, and that's what started to form us with the idea of the law of agency. So the law of agency tells us that we have a duty to present all offers to the seller. Everybody see that word all? Is there any offer I don't present? What about the low ball offer that's just going to make my seller mad? Do I have to present it? Yeah, we have a duty to present all offers to the seller when? As soon as possible. The law of agency says at that time that we're presenting that offer, at that time, we're also going to disclose any information that we have that may affect the seller's decision. Do I know something that a possible change of the property that could affect their decision? Do I know something about the buyer that could affect their decision? So the law of agency says I have a duty to present all offers as soon as possible, along with any information I have that may affect their decision. The Real Estate Commission is close. They say we're required to deliver offers immediately, but in no event later than how many days from the date of execution? Anybody remember how many days? I see a question mark written on your face. The Real Estate Commission says no later than, you were right, by the way, 3 days. So what the Real Estate Commission says is we present them immediately, but in no event later than 3 days. The law of agency says we present them as soon as possible. Those pretty much go hand in hand, right? The commission gives us a little bit of time, that in the event no later than 3 days. But bottom line, you guys, when do we need to presenting our offers? Immediately, as soon as possible. Now let's be reasonable. If your seller tells you that if they take a personal phone call at work between 9 to 5, Monday through Friday, they will lose their job. So if you get an offer at 10:30 on a Wednesday, are you going to call and risk them losing their job? Probably not. You know, if they say I can't take a call until after 5, then you call them at 5:01, right? That's what we mean by immediately or as soon as possible. We need to be within reason here. If your seller thinks they're going out of town and they're going to go on a cruise and they're not going to get the Wi-Fi package, then we need to have somebody else in their family maybe that can make a decision, somebody that can trust. And if they say, no, I don't trust a soul in my family, then maybe we need to take their home off the market for 5 days. Because if I get an offer on Monday and they don't get off the boat till Friday, I have violated license, law, and commission rule, haven't I? Even though it's following their instructions, I have violated license, law, and commission rule. So if they don't let a family member have decision-making authority, if they want to go on that cruise or go to Greece for a month without internet, doesn't that sound nice? Then they need to either make other arrangements, or we just need to take their home temporarily off the market till they can get back to us.
So Julie, on your first example about the person can't get a call. So if I were to leave a voicemail on their phone and follow that up with a text message in the event that they just happen to turn on their phone during the day, doesn't that count as communication?
You've done your part, right? You've done your part because you communicated with them. And so that would work. I guess my point was, when can we not get it to them immediately? What's a time that we may have to wait? And it might be that we have to wait for them to get off work before they will, I did my part and reached out at 10:30. I sent a text and said, hey, we got an offer, exclamation point. Call me as soon as you get off work, right? But now I understand on them, it's their job if they respond to that, but I guess I wouldn't want to put them in that temptation, because you know what they're going to want to do when they see I've gotten an offer? They're going to want it. So, conversations we have up front with our sellers. When your seller says, I can't take call, okay, when I get an offer, how would you like me to tell you and send you a text? Or would you rather wait, I contact you until you get off at 5? I'm all about the more we can resolve up front, the less room for problems we have somewhere down the road. That's kind of me. It's all possible. Keep it in mind, I don't have a crystal ball, so I can't tell you everything that could happen. When we submit offers to our sellers, at that time, we also need to notify the seller of any possible offers that may be coming. If you hear of one coming, maybe there was a showing this morning and the showing feedback said, buyers love it, going home right now to write it up. You know you have an offer coming, right? So when you present this offer this afternoon, you tell your sellers, by the by, our morning showing said they were going to bring us an offer. So we may get that as well. Once again, on its way and in your hand are two totally different things. Could that buyer from this morning change their mind? Of course. But we've heard, that's why it says possible offers. Any questions or concerns or on clarity or miscommunication about your commission has got to be worked out before we present the offer. We have to have all agreements to commission in writing before I can present the offer. That's part of our listing agreement. That's part of our agency agreement. Remember, we're not going to slip ourselves a bonus in to the offer to purchase and contract. We are not a party to the contract, thus we don't belong in the offer to purchase and contract. That's all in our agency agreement. And then we don't have the authority to accept or reject an offer on behalf. We just communicate. We can speak for them. We're only speaking on their behalf. I had a seller once, and he told me at the listing appointment, he said, if I can't sell my house for X amount, then I can't afford to sell. I will find a tenant and I will rent it out for a couple of years. And I said, I appreciate you sharing that with me. I understand what you're saying. I was listing it for more than that. So I felt confident that we could, get him what he needed to sell. He said, I'm not going to tolerate anything less than that. I can't do it. I said, great. We went on the market. We were on the market about 3 or 4 days, and we got an offer from one of those firms that try to buy low and then turn around and rent it themselves. So it was a low ball offer. I got the offer in and I called the man and I said, look, I know that you told me. I want you to know we had an offer come in this morning. It's for X amount. He said, Julie, I can't do it. I said, great. Have a nice day. I'll talk to you later. The conversation was literally that long. I still sent him, right? I had to send it to him so he could see it. But what I couldn't do when that offer came in, oh dear, I've lost my phone. It's a real estate agent. My eye's going to start twitching a little bit. But what I couldn't do when that offer came in is call the agent and say, yeah, he's not going to accept this. You with me? I still had to present it. I still had to. Jory, by the way, I'm not sure if you know, but this is a sign that we used to do for talking on the phone. Did you know that? She did not know that. So back in the day, before we held our phone like this, we held it like this. It was once brought to my attention that some of you younger people don't know what that means. And since I've lost my phone, I had to improvise. That's what we're doing. So anyway, you guys, what if something changed in his financial situation the night before and it was decided that he had to sell no matter what? And then he found out I rejected that lowball offer. Do I have an unhappy seller? You better believe I do. So even though they say I cannot accept, great. That whole conversation took me 30 seconds. Comments on that? Questions? Probably put my phone in the dishwasher or something. Knowing me, I should probably check that before I run it again. That's just the kind of thing I do sometimes. All right, let's talk about multiple offers. Multiple offers have always been around. However, in this day and age, we're certainly dealing with them a lot more often, a lot more frequently. Although we're starting to see changes in this market, it still doesn't mean that all multiple offers are always going to go away. Offers are to be presented immediately. Didn't we just decide that? Immediately, but with no event later than 3 days or as soon as possible, depending you're talking about. So I don't know why agents think multiple offers are any different. As you start to get offers in, when do we present them to their sellers? immediately. What if we call for highest and best Friday at 5? What are you going to do? Sit on them until Friday and present them all at once? No. License law and commission rule, law of agency says, when do we present our offers? Immediately. So you get 5 in today, you send them 3 in on Tuesday, 4 in on Wednesday. You guys, now my seller and I are going to get together and talk about all of them on Friday at 5 when we call for best and final. But the fact that there's multiple offers doesn't change license law and commission rule. We present all offers immediately, but in no event later than 3 days. We are going to present all offers in our hand. Again, in your hand and on its way are 2 different things. And we need to present all offers that are in our hand at the same time in no particular order. I cannot favor one offer over the other. I think we all know enough to know by now that it's more involved than the purchase price. There's more to discuss. It's not just what's the highest price, how much due diligence, how much earnest money, when do they want to close, what's their loan type? Are they asking for a bunch of seller pay closing costs? All of those blanks that we fill in, all of those factors play an importance when the seller's deciding what's the best offer. So just because it's the highest doesn't mean that it's the best. What if, back to Vivian's wrinkle, what if you're a dual agent? Better yet, what if you're a single agent, dual agent? Can I make my offer look better than everybody else's? Can I present mine first to see how my sellers feel, and then we'll present everybody else's? You're shaking your head. No, I don't understand. I'm going to make more money if I can act as the dual agent. Now I'm going to go get both sides. How is that not a win-win for everybody? The real estate commission says it's not about us. It's about that seller. If you're in a single agent, dual agency situation, or even just a dual agency situation, we still can't favor that offer over the others. The seller needs to decide which one is best for them. I had a post-licensing student last year, and he about this time last year, actually, end of summer, and he shared with us that he had a listing. He was a listing agent, and he got about 20 some offers, one of them being from the buyer that he was working with. As a provisional broker, particularly, I said, how did you handle that? And he said, I actually had my broker in charge present the offers to the seller. My BIC discussed with the sellers. He took himself personally out of the equation. I thought that was about the fairest thing that he could do. He said his sellers did not choose his buyer's offer. So, you know, but I think he took himself out of it. And I don't think that was a bad way to handle it. One thing I'm seeing in multiple offers, keep it in mind, we still got to send them a copy of the contract or the offer. They deserve a copy of that, right? So we got to send them on. But the other thing that I'm seeing that I really like that some agents are doing in a multiple offer situation is an Excel spreadsheet. So it's like, here's sales price, due diligence, and earnest money. And then you can say, like, here's the terms of offer 1, offer 2, offer 3, offer 4. It allows us to do a nice side-by-side comparison of whatever terms are important to your buyer. The other thing I like about it is what your seller's actually looking at doesn't include names. There's concerns of fair housing violations. Sometimes sellers look at names and think they know the buyer. Sometimes they look at names and go to Google to look the buyers up, or they go to Facebook to look them up. Keep in mind, we're still sending them a copy of the contract. So if they really, really want a name, or excuse me, a copy of the offer. So if they really, really wanted names, they could get it, right? And they could go look it up. I may be none the wiser. But what I like about the spreadsheet is that's what we're trying to get them to focus on. And we're taking the names out of it. Try to help keep, you know, really bottom line, all the sellers should care about is, can they afford it? Can they get loan approval? Can they get the money that they promised to pay me? They shouldn't care about who the buyer is. Sellers agents, we have a duty to treat all buyers and their agents the same. Remember, these are customers. So the buyers in the transaction, the buyer's agents in this transaction. If you are the listing agent, We owe these buyers and their agents honesty and fairness. So you'll get the call. You'll get the call. You know, what's the best offer you have? We'll talk more about how you respond to that in just a second. You may get the call, what's the highest offer that you have? Or what's everybody else offering? Or one of my favorites is, what's a term your seller would consider favorable? Guys, bottom line, what we do for one, we do for all. I think to treat everybody honestly and fairly, if you say a favorable term of my sellers is to close at the end of October, I think in all fairness, don't we need to share that with all offerors? If that's something we share with one, so we got to treat everybody the same, treat everybody equally and fairly. This cute little house you're looking at, this is the listing I was sharing with you guys. I got 2016 or 2017. This is when we were first hearing about multiple offers and we were trying to figure out what to do with them. This was my little listing. It's a cute little house, isn't it? It's in Greensboro. I'll tell you what's wrong with it. It's a 3-bed, 1-bath. And I said, you know, it's 2022, or back in the day, it was 2017. Everybody wants their own bathrooms. I said that one bathroom is going to be the problem. You know, I had heard about some listings having multiple offers. I wasn't prepared. I mean, in 3 days, we had 20 some showings. As I mentioned earlier, that resulted in 6 offers. All were great. If I received any of those independently, we wouldn't have had to counter anything. All 6 of them were great offers. Pretty much it for my seller, it came down to, we'll pick that one. I mean, it was like that. There was no way to just differentiate. And at the end of that transaction, because then they got pregnant, they tried to terminate, you know. So at the end of that transaction, once we got through it, I thought, you know, what a crazy situation to have 6 people wanting to make an offer. The neighbors are reporting showings. Like I had agents lying down the driveway and out the street, around the corner. And this was the start of all this mess. I guess if I would have known now that that was the start of what was going to be the normal for the next, 4 or 5 years. But I just thought I was the fluky one. I thought I was the unique one. And we're getting ready to live it. The fact that we have multiple offers is not a material fact. Multiple offers is not a material fact. Whether or not we disclose that we have multiple offers comes from instructions from our seller. The seller tells us if we disclose that or not. And we, again, need to have a conversation with the seller. Some buyers, when they find out there's another offer, it makes them withdraw. They say, I don't want to get involved. I don't want to play. I'm just going to go find another house. Other buyers, when they find out there's other offers, it's going to make them up their game. It's going to give them the challenge. So as agents, we have these conversations with their sellers. Some buyers are going to drive away. Some you're going to drive up. How do you want to proceed? If your seller doesn't want you to disclose that there's multiple offers, when another agent calls you and asks you, is there another offer? Guys, I still can't lie. Even though my seller doesn't want me to disclose, if I have an offer in my hand, I can't say, I can't lie. So if another agent calls and says, do you have other offers? And my seller's told me to say no, then my answer is something like, my seller doesn't wish to disclose that. It's pretty truthful, isn't it? I'm following my seller's instructions. We cannot share terms of an offer without permission of the offeror. We cannot share terms of the offer without permission from the offeror, the person making the offer. So again, you guys, hear me when I say, when the other agent calls you and says, what's the highest offer you have in your hand? When the other agent calls you and says, what's the term to beat? There's no law saying they can't call and ask. You can always call and ask. The law dictates how I answer that, how I respond. I cannot respond. I cannot share that information unless I have permission from the other offerors. Do you think any offeror in their right mind is going to give you permission to share the terms of their offer? Heck no. Why would you give somebody else, why would they give somebody else that playing field, that advantage? So many, especially new agents, you guys get thrown off guard when somebody else calls and asks. There's no law that says they can't ask. The law is how you respond. Everybody with me? I cannot disclose terms of an offer without the offeror's permission. You know what they're banking on? They're banking on you not taking 302 with Julie and not knowing that. So let's jump out of here real quick. And let's go look at our last form. Oh, and I need to put that one on test pass too. I'm about 99% sure this is our last form. In the event I've skipped one, I don't want to say we're done because then we got to cover it on Wednesday, but I'm almost certain that this is our last one. And this is a form, it's called a response to buyer's offer. Let's think of this form as a letter from the seller to the buyer. So an offer's been made and the seller is using this form to respond. Again, this is another one of these forms that's always been around, but it's had new life breathed into it in response to this crazy multiple offer world that we're living in. So if you get a bunch of offers and none of them are good, you can consider using this form. So we have a note to the buyer regarding the offer to purchase on this property. Here's the date that the offer was made. And then we have 3 choices here, and we're told to only check one. So we got 3 options here. First one says, thank you for your offer. We cannot accept the offer as written and hereby reject it. However, while this is not a counter offer, we would favorably consider the following changes. I've rejected your offer. I'm not going to counter with you, but here's the chance, the opportunity for the seller to put their cards on the table. This is what I want to do. This is what I would consider favorable. Goes on to say, if the above changes are acceptable to you, please submit another offer with the noted changes. Please understand that until an offer has been accepted, we are free to consider and may at any time accept any other offer to purchase presented that contain terms and conditions satisfactory to us in our sole discretion. Does the seller have to wait on your buyer to present another offer? Do they have? No, the seller is free to accept any offer at any time, aren't they? All we've done is a polite way to reject it. And we're saying, by the by, if you want to bring me another offer, this is what I would consider. This is what I would like to see. I think this first option works really well for the low ball offer. The seller's up here, the buyers, how many counters do you have to get us, together? So if it's so low, if it's so off, I always say, what can a rejection or a counter offer hurt, right? But this might be an option for you to say, look, we're not going to play around with counter offering. If you want to bring me something, then, this is what I'm looking for, and we'll consider it. Our second option here was added to this form as a response to the multiple offer world that we're in. So the second option is new since July of last year, 2021. Thank you for your offer. Please be advised that we intend to consider all offers on the property received by, and here's a date and time. Should you choose to submit another offer, we encourage you to submit your best offer as soon as possible and in no event later than the date and time set forth in the preceding sentence. If you neither submit another offer nor withdraw your current offer, we will consider your current offer along with any other offers. Once again, the seller is free to accept any offer at any time. Even if they call for highest and best, you guys, if they don't want to wait until 5 p.m. on Friday, if the offer comes in today, they don't have to wait till 5 p.m. We are free to accept any offer at any time. So in this scenario, an offer has been made, and now the seller is notifying the buyer that there are other offers. So you have a chance to either proceed with your offer or up your offer. This is your date and time. This is your cutoff. Again, this was the new one that was added in response to the multiple offer. And then the last one is the politest rejection I've ever seen in my entire life. Thank you for your offer. We cannot accept the offer as written and hereby reject it. I think the only thing missing from that is thank you, have a nice day. I mean, that's the nicest no I've ever seen in my entire life. Again, can you say no in a text? Can you say no in an email? Of course you can. But this form allows us, if you want to be more official, if you want to be more formal, then we have a form that we can reject that offer. Only the seller signs it. It's not a contract in any way, just the seller responded to the buyer's offer. No acceptance in this letter whatsoever. It's all a rejection. Questions on this one? Comments? Response to buyer's offer? I think many, many years ago, new agents were taught to use this form. Because if you ever work with a seasoned agent, they're using this form. I think somewhere this form kind of disappeared. It lost popularity. And like I said, we saw it come back with this crazy multiple offer.
No, I feel like showing time notification replaced it.
You think it was showing time? I guess that could be it too. Because you could just go in showing time and say no more showings, we're under contract. So I guess that's one way, fine. So you're right, Jory. Thank you for that. Probably the reason for this last one doesn't exist anymore because now we got, like I said, text message, email, showing time, different. But I still do think these first two, especially this one, I mean, I've used this on a low ball offer. Like, we're not going to waste our time countering. It's just not worth it. So if you want to come here, we can. And then same thing when you're calling for highest and best. And you can send messages out through showing time. So if you want to notify all the showing agents, I'll let you guys go to showing time for that training. All right, so multiple offers. Questions on multiple offers, comments? A little review on contract modifications and counter offers. Any change to an offer is a rejection and it creates a counter offer. Guys, I don't care how small and insignificant that change may seem. Any change to an offer rejects the original offer, creates a counter offer. All parties have to agree on all points of the offer. That's what we're trying to say right now. All parties have to agree on all points. When it comes to contract modifications and counter offers, the Real Estate Commission offers us some practical pointers. Any change to an offer should be initialed and dated. Boy, this is old school, isn't it? This is how we used to have to do it. Could we still do it on pen and paper with pen and paper? Of course we can. So even though we've moved on technology and we're using text and emails, don't we still have to acknowledge changes? Don't we have to get all parties to agree to the changes? So even though we've kind of gone away from the old school way of doing it, where you cross out, initial and date the change, we still need that meeting of the minds. We need to show the communication, even if it's text messages back and forth between the agents. We still need to show that coming together, that meeting of the minds. Real Estate Commission reminds us that all counter offers need to be communicated. I think that one's pretty self-explanatory. Communication is key. If you make lots of changes on your offer to purchase and contract, you're going old school and you're doing it pen on paper. After a while, once you make a few changes, it's going to be hard to read. It's going to be hard to make out. So the commission says, once you've come to terms, once you've come to an agreement, then you need to put it on a nice new clean offer to purchase and contract, get everybody to sign that. Keep your original, keep the communication, because that shows the meeting of the minds. I think this scenario we see mostly today. Buyer's agent writes up the offer on the offer to purchase and contract, sends it to the seller. Now the agents start negotiating back and forth via text, right? So the offer that was sent, it just kind of landed somewhere in the seller's court. Now we're communicating via text. Once we come to final terms, we're going back, redoing the offer to purchase and contract, having the buyer sign that, and then sending that to the sellers. My point to you is keep all the communications between you and your client and you and the other agent. Always keep that, because that shows the two coming together. Guys, remember what we document? Everything. And that absolutely includes communication to form a contract. If we start back up in round 2 of negotiations, we need to modify the contract in writing. So, maybe we say something like, in lieu of repairs, let's reduce the purchase price. Well, that reduction in the purchase price only counts when we have it in writing. So we got to have documentation of that. Remember, we have the agreement to amend the contract, or you could just go old school and actually cross it out on the contract and everybody initial and date it. Sometimes the seller may ask the buyer to consider terms. They're not countering. They're just saying, would you guys consider this? Would they think about doing that? If that's what they're doing, then we need to make clear of our intentions. If they're just kind of sending some feelers out there, trying to learn how to respond, how best to respond, and they're just putting feelers out there, make sure in your communication you recognize this isn't a counter offer. We looked at that article from the commission last week about how agents' emails may be binding. And while we haven't seen this case yet in North Carolina, we need to be very certain that when we do communicate with the other side, the other agent, we're letting them know, look, this is not a counter offer. My guys were just curious, could you close on this date instead of that date? I'm not countering, I'm just asking a question. So if that's all we're doing, considering terms, we need to be clear in our communication that it's not a counter offer. And then, of course, when in doubt, call your attorney. Remember, we're helping our buyers and sellers form and create legally binding documents. So we need to make sure if there's any legal questions, again, you guys are going to ask. Buyers and sellers don't know what I am and am not allowed to do. So they're going to ask. We need to know how to respond. Furnishing copies of our offer, delivery of instruments. How many remembers how many days I have to deliver instruments? And then we'll talk about this a little bit more. How many days do I have to send executed instruments? Yep. If you remember 3, you're pretty much in good shape, aren't you? So, so first off, let's talk about what the heck an instrument is. An instrument is just any document related to this transaction. Instruments typically start with our agency agreements. And then at some point, hopefully we get them under contract. And then at some point, hopefully after that, we get them to closing. So we got different sets of instruments, right? Different sets of documents. And what the commission rule says is that I have 3 days to deliver from execution, from them being signed. So we get an agency agreement signed. You send that to your new client. You say, here's our agency agreement. I look forward to working with you. That client later goes under contract. Once it's signed, we send them a copy of that contract. Here's a copy of the contract for your records. We get to closing. We make sure that the attorney is getting those documents to our clients. Couple things here. Let's make sure we're good on a few things. First off, what's my job? My job is to deliver it. What they do with it when they get it, not on me. They're going to file it away, or they're going to delete the email. Not really my responsibility, is it? My job is to deliver it, get them a copy in their hands. I would suggest sending that via email, for example, where you have a sent email with a date and time stamp on it. You're going to document that sent email. Yep. If you send it during .loop or DocuSign or Zip Forms, they should have a trail, a history of you sending that stuff as well. So we want to make sure that we document that we sent it. We need to, I think one of the things that kind of got lost on us is things we got swept away in this market. If you're the listing agent and you get 30 some offers, let's say you get 35 offers, only one of those can become a contract, right? Guys, we got to keep the other 34 offers. So even though they never become a contract, we got to keep all those offers in our record, in our files. Because what do we document? Everything. How many originals of these documents that we need? We just need one. Like we said earlier, once upon a time ago, before the internet, you just had hard copies, and you might have had the seller sign a copy and the buyer sign a different copy. And that was acceptable as long as the parties were signing the same thing, as long as it was a true copy. They weren't signing two different forms. I just don't think we're seeing that as much today. Now, because of electronic means, we can get buyer and seller on the same document. But with that being said, that's not changed. How many originals do we need? We really only need one. We can make copies. You know, both buyer and seller are going to get a copy, or the original if we're online. Both agents need a copy, listing agent and buyer's agent, the lender, the attorney. Any questions? I'm going to stop sharing just for 1 second. I want to see, and I'm watching our time too. All right, so I know we're a few minutes early, but we're going to go ahead and boogie a few minutes early because I don't want to start anything and then have to stop and then just recap. So what's tomorrow look like? Closing disclosure 4. We'll do that for not tomorrow. See, Wednesday. We'll do that first and get it out of the way. If you have a hard time accessing it or you can't find it, please just reach out to me. Once we do that, we're going to finish up. We're almost done with 11. We got to talk about an installment land contract and option to purchase. I kind of call them alternative land conveyances. We got to go through the commission's requirements to talk about your license, how you keep it active, how you keep it from falling expired. I don't want you guys to have to go through pre-licensing again. So we're going to talk about how we can prevent you from doing that. And then we're going to do a review of everything that we've talked about in a very short time together. And then we're going to go over the exam rules and expectations, and then we're going to take lunch, then we're going to take a test. So that's what Wednesday looks like. What questions do I have? Comments or concerns? Thoughts on life? Yeah.
What was after licensing, how to keep active, it expired? What was that?
A review.
Oh, review.
Yep. Our review.
And then lunch and then test.
That's it. Like I
Okay.
said, as long as
Can
I
you
get
go
you guys.
ahead and show me how to get to the blank CD
Yes,
since we have a few minutes?
thank you. So if we go into Learn, Test, Pass, and the blank CD is down here under 6B.
Oh, because I went to forms. Okay.
Sorry about that. I'm glad you asked then. Thank you. It's down here under 6B. And Patricia, what you should be able to do, this little arrow right here, is to download it. And then once you do that, from here, you should be able to print it, whatever you up here at the top. So you may just need to first download it from Learn, Test, Pass here. And then come up here, and then you can print it to, you know, wherever you're going to print it out.
Gotcha.
You guys can do this front or back, or you can do 2 pages, one on each side. Sometime for your test, I need to see both sides. I want to make sure that it's a blank CD and you don't have anything written on the back side. So that'll be part of our little check-in process that we'll talk about. Sometimes students like to have a backup of this. just in case you mess up and you want to start over. So you're welcome to have more than one blank CD for the test. I just need to see all of them before the test. If you want to come with 2 or 5, I'm okay with that. But this is kind of the trust system that we have, right? If you're bringing 5, I need to see all 5. But sometimes students do like to have an extra just in case. I've had students show up with 4 pencils and 3 calculators, and they're just prepared for anything. But what I do know about the test is we'll get through it. We'll get you through it. So if your calculator stops working in the middle of the test, breathe and know that we will get you through it. As a reminder, your homework recommendation is also in this 6B, the same category. And the one we're going to do on Wednesday is closing problem number 4. So make sure you do that with the solutions. And remember, I'm around tomorrow. You guys have any questions, don't hesitate to reach out to me. Let me help you. What else?
Should we do 4 and 5 or just 4?
If time allows, we could do 5 as well. I'll save that to the very, very end. We'll see where we are. Like I said, I need to get you guys started no later than 2. But yeah, if time allows, we can go through. Okay. All right. Well, you guys have a great evening. I hope everybody has a good day tomorrow. And I will see you at 9 a.m. on Wednesday. We'll knock this one out. Sounds good.
Thank you, Julie. You've been a great.
Absolutely. Thank you. Have a good evening.